Thank you. Good morning, all. This hearing is in the matter of CFI 050-2025 and CFI 051-2025 and is being held by way of video conference before His Excellency Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Quinn Emanuel Urquhart and Sullivan. Lead counsel is Mr. Tom Montague Smith, KC, assisted by Mr. Tom Stewart Coates. The defendant in CFI 050-2025 is represented by Altanimi and Company, and the first defendant in CFI 051-2025 is represented by Hamdan Al-Shamsi, lawyer and legal consultants. Lead counsel for the defendants is Mr. Michael McNutt. Thank you, Your Honor.
All right, thank you. I heard a little bit of feedback. Can we make sure that everybody who is not speaking switches their microphones off? All right. Mr. Montague Smith, Mr. McNutt, have you discussed the order in which we'll proceed with these applications and submissions?
Not yet, Your Honour, and that's because, sorry, Mr. McNutt's got a lot of feedback, I'm afraid.
Mr. McNutt, could you switch your microphone off, please?
Yes. Your Honour, just there are a few pieces of housekeeping. We were told about Mr. McNutt's representation about 10 minutes ago, 15 minutes ago. Mr. McNutt is not registered on the DIFC Part 2. And not only that, we understand he is not qualified to be registered because he is not a qualified lawyer. That's my understanding. We are very much in your hands. Two issues arise out of Mr. McNutt's instruction. The first is that obviously you were told by Mr. Ravindran and Ms. Golkanath that they did not have counsel.
Excuse me, Your Honor. Your Honor.
Sorry,
yes. Mr. McNutt, would you just wait? What I'm going to do is allow Mr. Montague Smith to address me, and then when it seems a suitable time, I'll ask for you to respond, Mr. McNutt.
Well, Your Honor, I would just politely request that our good colleague, when he raises an issue and he says the first issue and then he stops, I should be allowed to reply, because what he said is completely false.
All right.
Part 2 registration is done, and I don't appreciate the Quinn Emanuel has consistently attempted to disparage me in multiple jurisdictions. My good colleague is not properly informed. We've advised Quinn Emanuel we will file a bar complaint against Quinn Emanuel for their conduct, and I'm simply suggesting that my good colleague not lend himself to be part of that bar complaint by repeating statements that are false. Part 2 registration is done. Please feel free to confirm that with the register. Thank you.
Yes, well, Mr. Montague Smith, I think your information, do you know how up to date it is?
Well, my instructions list has checked on the registry website, and I think that they've checked with the registry. We'll check again.
All right.
But the point that arises as well, there's 2 points that arise. The first is that Mr. Ravindran and Ms. Golkanath said they didn't have counsel for this hearing, and that they had to be separately represented. And assuming Mr. McNutt is properly on the record, he now appears before you for everyone. And so they do have counsel and they are represented, and he is briefed on the whole of the claim in relation to Mr. Ravindran. So you've been told that they were unavailable, they didn't have counsel who could properly represent them, and we would suggest that that does not now appear to be the case. The second point is that Mr. Ravindran and Ms. Golkanath have still not provided a skeleton argument in relation to the collateral use.
Welcome to DIFC Courts. For the DIFC Courts registry, please press 1.
Whoever's
For the
speaking,
registration
please.
of practitioners and the pro bono program, please press 2.
I've muted them, Your Honour. So sorry.
Right.
I think that's
All
from
right,
my
thank
end.
you. Okay.
Sorry. So the point was that they
In a
simply
minute,
haven't.
please, Mr. McNutt. I'm going to allow Mr. Montague Smith to speak for a little while and then ask you to reply. Otherwise, we're never going to get there. Yes, Mr. Montague Smith.
The skeleton arguments were due on Tuesday. Obviously, timetable's pretty compressed. and they haven't provided their skeleton argument. It's now 2 days late. They haven't said when they're going to provide it, and there are a lot of moving parts. There's a lot of new points raised in the skeleton that has been provided by Mr. Ravindram, and it is going to significantly interfere with preparation for that application if we get another document. So we're in your hands as to how to deal with it, but we would suggest that it would be unfair to now just allow them to launch a whole nother document with a whole load of new points on us, and they just have to play the cards they've got. It is what we suggest. In terms of order, I was therefore going...
Let me, just a minute. I'll ask Mr. McNutt to respond to those matters before we get to the question of order. Mr. McNutt.
Thank you, Your Honour. And I apologize that it seems like, I believe you said we're never going to get there if I interrupt. My problem is that in the last session on June 25th, you gave great leeway to my good learned friend to speak for a prolonged amount of time, and then the other side, and I appreciate that, maybe it's a style difference. My issue is that he tends to say things that just kind of are wholly speculative. For example, he said, Mr. McNutt is briefed for the whole of the claim. He just said that. That's not the case. He said that the skeleton is late, and as a consequence, it would be unfair to have new arguments. There's no suggestion there's new arguments. So there's a whole lot of supposition and speculation, which I think, given the quality of the counsel on the call, we shouldn't be doing that. We shouldn't be wasting your time.
Right. So can I cut to the chase? Can I cut to the chase, Mr. McNutt? First of all,
I'd like to cut to the chase as to when I was actually instructed, because that is the cut to the chase.
All right.
I am not fully briefed on the other defendants' pleadings. I was only instructed, as a consequence of your order, that the collateral use will continue. So in a simple measure, if you check Ryuju's application for or defense against the collateral use, that is a different opinion for enforcement of a allegedly definitive partial summary judgment to the question of collateral use for a Part 8 claim in aid of foreign proceedings, which have just started. So the reason that I was instructed to assist was to guarantee that at least defendants would properly be heard and not be steamrolled over by claimants because they had no other possibility. So my engagement is extremely limited to only the collateral use. And you will see me make no submission on any other matter regarding those two defendants. Thank you.
And Mr. McNutt, before you sign off, so far as your submissions on the collateral use application in relation to the 050 defendants is concerned, are your arguments to be confined to those which are set out in the skeleton of argument by the first defendant in 051?
No, the proposal, and it will not prejudice at all. I've spoken to ATCO, and I've simply requested that at the end of the day, they're going to provide me by around 5 o'clock, the draft skeleton. I should be able to provide it no later than 8 p.m. tonight to the opposing counsel. That skeleton will include already documents from the submissions that are already in the file, for which our good colleagues have already prepared a draft settlement skeleton. So there's no prejudice to them receiving that this evening in order to prepare for a determination or discussion of that application late tomorrow afternoon, which has already been proposed between counsel, since that is actually the last matter that should be determined. So we should be able to provide a brief skeleton argument, and there should be no way, shape, or form that the opposing party can complain about that skeleton, since it will contain no new arguments and will be isolated to the documents already in the pleadings, the evidence that's already there. So it's remember, the skeleton is just to assist the court. I'm more than happy to plead without a skeleton, but I'll still plead.
Mr. McNutt, there are at least two purposes for a skeleton. One is to assist the court. The other is to give the other party notice of the arguments that would be made. Now, I'm a little confused. You said in the course of that submission both that there were new arguments and that there are no new arguments. I'm not sure which it is.
No, I said there are, forgive me if that wasn't clear. First, my understanding is a skeleton argument is not obligatory. I agree there could be some utility, but it is not obligatory to provide one, number one. Number two,
Mr. McNutt, I'm sorry to interrupt you, but I don't want to go off on false. A skeleton was directed in this case.
I agree, and I agree the defendants did not follow the direction. However, that direction, if the court does not want the benefit of its own direction with a skeleton, great, we won't provide one, but we'll still plead it. No, it's in your hands. No,
Mr. McNutt, I don't want to get into an argument at this stage, but it doesn't work that way. A party cannot choose not to put in a skeleton and then advance arguments of which neither the court nor the other party has any notice. But all of this may not be necessary. I'm trying to find out, first of all, whether the arguments you propose to make in relation to the collateral use application in CFI 050 are the same as or go beyond and are different from those which are indicated, set out in the defendant's skeleton in CFI 051. If they don't go beyond those arguments, then I don't think there's any prejudice involved. If they do, it might depend on what they are.
Your Honor, I apologize. I thought I answered that question. The only difference between the arguments is the factual difference on the basis of the claim. Otherwise, the arguments are the same. Thank you.
All right. The second point that arising from what you said, Mr. McNutt, I thought you made reference to counsel having discussed or agreed that this application, the collateral use application, would be dealt with last. I wasn't aware from what Mr. Montague Smith said that there'd been any such agreement or discussion.
There's no agreement. There is a discussion.
I see. I see. Well, I'll go back to you, Mr. Montague Smith.
Thanks. I mean, if by discussion it said it was proposed, and the response was, we'll see what the judge would like to do, because he's already told us that he'll control it.
All right. What I wish to do is this. In the absence of agreement about the order of submissions or applications, I will deal with them this way, leaving aside the application for the collateral use of documents for the moment. First of all, Mr. Montague Smith, you will address on the claimant's applications. Then Mr. McNutt will respond to those applications and make his submissions on the defendant's applications. Then, Mr. Montague Smith, you will reply on your applications and respond to Mr. McNutt's submissions on the defendant's applications, and then Mr. McNutt will reply to your submissions on the defendant's applications. I propose to leave the collateral use applications until tomorrow so that Mr. McNutt or his instructors can file the skeleton, which they've indicated they'll file by 8 p.m. tonight. Mr. McNutt, can I ask, I'm trying to work out from the scene behind you, where are you located?
I am presently in Dubai in the offices of the solicitors. Yeah. Thank you. And I'm sorry, there appears to be some technical problem that had frozen our screen, so I apologize if there's a problem. We're trying to get IT to solve.
I can see you fine. So by 8 p.m. you meant 8 p.m. Dubai time.
Correct.
Can I just make one observation on the order of speeches that you've suggested? There are 3 applications effectively out there. There's a jurisdiction application, and that's by Mr. Ravindran. There is a set-aside application and various associated applications for security and fortification and so forth. That's also by Mr. Ravindran. And then there's my continuation application. Now, my continuation application is really very simple. in the sense that I've made my application to you for the ex parte. The points that are made against that application are the same as the points made by Mr. Byju Ravindran in his set-aside application. And so the way I had sort of thought it might go was that Mr. Ravindran's jurisdiction application could go first, with me then to respond, and then the set-aside application, and then me to respond. Simply because, in effect, we've done that first bit already in the ex parte. Everyone knows what the arguments were, and really what we're dealing with today are the points that are being raised by Mr. Ravindran. So that's how I anticipated it might advance. But I'm in your hands. It's just that my submissions may be quite short otherwise.
Mr. McNutt? Now, Mr. McNutt, you are frozen. I don't know if you're able to hear me. Yes, I can see you again, and you are moving. Yes, Mr. McNutt. Were you able to hear? I
apologize. Your Honor, can I suggest? I apologize. I can't really control this. And let me also apologize if I seem a bit disgruntled. I was just frankly offended by the start of this, that we've already had a reference of a bar complaint and they just keep going, and that's not correct. Okay, and I apologize for that. You'll see a much better disposition shortly. If we could please, I would suggest we're calling the registry now. It appears to be not on our end. Otherwise, we're going to keep getting interrupted. And I would suggest a 2-minute pause to let the technicians figure this out so that none of us are frustrated. And my good colleague Montague Smith, I apologize as well. I don't mean to break up your rhythm. Thank you.
All right, what I will do, it is now 10:19. We'll take a break until 10:25 for the technicians to talk. And also, Mr. Montague Smith and Mr. McNutt, are you able to still talk to each other and discuss the proposal that Mr. Montague Smith just made about order of submissions? If you reach agreement, you can tell me. If not, I'll resume at 10:25. But for the moment, I'll give you that break to try and sort out the technology and to talk.
If we don't,
gentlemen, I've just joined the broadcast, so bear that in mind.
Thank you.
Did you want to have a further discussion about the matters that I left you to talk about?
No, thank you, Your Honour. I was just trying to get some information about the DIFC registration.
Right. Well, I'm going to tell you what I have been informed by the registry, and it is this: that Mr. McNutt made an application yesterday. It has been conditionally accepted by the registry. It is the conditions were subject to Mr. McNutt providing a practicing certificate and payment of the appropriate fee. So far as the fee is concerned, the registry tell me that Mr. McNutt has informed them that he's paid the fee, but it hasn't formally come through the registry's process yet. So far as the practicing certificate is concerned, Mr. McNutt has provided a practicing certificate, but the registry have not been able to verify it in accordance with their processes yet. So the position is somewhere between the position that you were both putting earlier. What I propose to do is to permit Mr. McNutt to appear for now, and we will keep the position under review to see that the conditions that were put on Mr. McNutt's registration are satisfied.
Very good. Thank you, Your Honour. In terms of order of submissions, yes. We've discussed and agreed that it'll go like this. First, jurisdiction. Second, set aside. And within that, continuation. And then third, fortification and security. And Mr. McNutt has said that he, in advance of his jurisdiction application, he wants to make some general comments, which he says will be uncontroversial.
Okay.
I don't have any objection to that, but obviously it needs to be kept within bounds. But there we are.
All right. Now, do I understand in that scheme, Mr. McNutt would make submissions on jurisdiction. Mr. Montague-Smith would respond to those, and Mr. McNutt would reply before we go on to set aside and so on.
No, I think it's going to go. Otherwise, we're going to be going backwards and forwards all day. So I think the idea was jurisdiction, response, set aside, response, fortification, security, response. Obviously, if somebody else has got something additional they want to say, and Your Honour wants to hear it, then you'll ask us questions.
But within that framework, then, so Mr. Montague-Smith, you would respond to Mr. McNutt's jurisdiction submissions before Mr. McNutt makes his set-aside submissions.
But that's the idea. Yeah. We can obviously, if you'd rather do it in a different way, then
no, that's fine. Mr. McNutt, you're agreeing that's part of the matter that you've agreed to, is it?
Yes. However, my understanding is procedurally, I still have a right of reply, and I would do that. I would do that after jurisdiction. So I would go, talk, counsel would answer, I would reply, close the subject, move to set aside.
All right, we'll do that. Now, Mr. McNutt, you want to make some general observations, and I'm sure you're experienced in all of these matters, and you know very well I'm not a jury, and I only want to hear matters that are pertinent to the particular applications we're dealing with.
Yes, thank you, Your Honor, and thank you. First, this is the first opportunity to present matters. So you can imagine, after 70 days of a freezing order obtained ex parte, Mr. Byju Ravindran is quite unhappy, call it, with certain things that have occurred, in particular, the lack of full and frank disclosure by claimants in obtaining the ex parte order, which will be discussed in these proceedings. There's some housekeeping issues that or I call them housekeeping. A couple of things based on the last hearing on the 25th. I just have a concern that I mentioned earlier, that opposing counsel will proceed down the line of argument without still full and frank disclosure, not necessarily by intention by my good learned friend, but because of the information he has. And I would just mention that in that circumstance, I would politely raise my hand, because the biggest issue in this file is that on the ex parte hearing, and again at the return date on the 25th at the directions hearing, there was, again, multiple submissions that were not full and frank, which we will discuss. And I do not want to be run over in those objections, in a sense, from opposing counsel. So I would just ask that the objection be dealt with when raised, and I leave it to Your Honor to determine that. I appreciate, having done a little bit of due diligence about yourself, Your Honor, that you do respect procedural rigor. And as that might be from your French side, I would propose, because in Paris, as you know, under the civil law, we are quite oriented on procedure. So one thing you'll find is that I'm kind of a stickler on procedure. So thank you in advance for that. The skeleton arguments that my good learned friend and his colleagues have presented are frankly improper and in direct violation of the practice direction number 2 of 2016. And having just come on, I was quite shocked at the brazenness of the violation. A violation can be accidental, but not by intention. And here it's by intention. And if we look at the practice direction, paragraph 1, it states that skeleton arguments by parties before trial in consideration of heavy applications should not exceed 25 pages. None of these applications are heavy applications. They're all ordinary applications. And ordinary applications are limited in paragraph 2, pursuant to RDC 2339, are limited to 15 pages. Now, when I look at my good learned friend's skeleton, and I would ask that we do that together briefly, I would ask you to please look at his attempt to bolt on a skeleton in paragraph 11 from a prior proceeding, the ex parte hearing. So in part 11, paragraph 11, here at an inter partes pleading, he instructs you and I to just add on a total of 77 pages from his first ex parte on top of his 25. So the skeleton is in fact close to 100 pages, which is just a total violation. In addition, the skeleton they also propose and use as a form of evidence, not merely as a skeleton, as we mentioned, as a demonstrative tool, or to help the court and our good, the opposing counsel know what's going on. So here we have just a flagrant violation, and this expands not only the page limit, and I'm not a stickler for how many pages in that sense, but what it does is it conflates. If you look at the ex parte skeleton, it conflates the arguments between defendants 2 and 3 and defendant 1. And if you look at the ex parte hearing, the conflation between the different defendant groups and the different applications is palpable when you review that, as we will soon see. That means that and I've reviewed it, we're okay. I'm just saying that creates complexity unnecessarily for defendant 1, because there is no reason to have relied on the ex parte skeleton. Anything they wanted to rely on, they could have quite easily put in. However, had they done that, they would have definitely exceeded the page limit, which is a problem. Now, the other thing that I've noticed is there's repeated references to Australian law in an attempt to pander to the good court, and I find that quite remarkable. The fact is that it is settled law that the last resort in the DIFC is the law of England and Wales, pursuant to CDC Rule 29.132. And that rule provides that non-DIFC law means DIFC law or any other force in DIFC, the law of any jurisdiction other than DIFC, which it doesn't apply. 3, law of jurisdiction agreed by the parties, that doesn't apply, except for the fact that the law governing the onshore guarantee and the credit agreement and alpha is U.S. law. And the law of any jurisdiction which appear to the court to be the one most closely related to the facts and the persons concerned in the matter. Well, here, the facts are not in the DIFC. The facts are elsewhere. The facts, the persons concerned in skeleton paragraph 116, I believe, our good learned friend admits that Byju Ravindran, defendant 1, is not a resident of the UAE, and therefore there is no nexus from a personal standpoint with the UAE as far as his person. And consequently, you must go to paragraph 5, which is the laws of England and Wales. So notwithstanding my experience with Australian laws, which I have no problem with and which I'm a fan of, unfortunately, those laws must play second fiddle to the U.S. and third fiddle, in fact, to the laws of England and Wales. And I just want to make sure that's upfront recognized. The use of the ex parte application and the hearing itself was an abuse by the claimant for the following reasons. In order to mislead the court, it only can be done on an ex parte basis. On an inter partes basis, defendant 1 and counsel would have been able to pick up on the lack of full and frank disclosure, and this misrepresentation and omission was expressly sought to obtain relief from Your Honor and the court. Now, I appreciate French law doesn't apply, but had I done that in France, I, as counsel, would be subject to a criminal offense in France, notwithstanding litigation privilege. You're not allowed to intentionally mislead the court in order to gain advantage. And here, we believe there was an intentional misleading of Your Honor, which we find reprehensible. And the reason this is relevant is the ex parte order is supposed to be, the return dates should be listed on an urgent basis to prevent the damage. Now, the claimant has taken advantage of the order, obtained relief in the Dubai courts for certain things that were not in all likelihood foreseen by Your Honor, which we'll discuss. And more importantly, they are in contempt presently, a self-declared contempt of your order, paragraph 27. They have no shame in admitting that you specifically ordered, if they wanted to take information out of these proceedings, they were required to do so only with your consent. And I would ask that we just briefly look at the order at that section.
Mr. McNutt, yes, I'm concerned about this.
Please.
Can you just pause for a moment? One of the matters that you raise in opposition to the continuation of the freezing order and I think the proprietary injunction is a lack of full and frank disclosure. I don't want to have this argument twice. You're going to make those submissions in relation to that. I don't want you to sort of top and tail Mr. Montague Smith. I would ask you.
That's fair. That's fair. I didn't intend to do that. That's a fair comment. My intention was not that. I think there's a difference and I'm happy to articulate the difference. The burden of proof for the continuation rests with the claimant. What I'm discussing right now is not a continuation argument. It's different. This argument is quite simply highlighting the abuse to obtain the ex parte order, not to continue the order. That's a fundamentally different argument. And it is outrageous that the ex parte order test, the court and your good honor assume, because of the burden of an ex parte application, that you are being presented facts and evidence assuming the full and frank disclosure requirement is met. That's like a precondition for you to consider. And in this case, not only was it not met, it was intentionally not followed. That's a gross abuse. That's a gross abuse of the process of an ex parte application, totally independent of the argument why it should continue. That's different than why they shouldn't get it in the first place. Now, I appreciate that you will not want me making resubmission on the why they shouldn't have had an argument. I agree, and I will not do that. When we get to continuation, I will only discuss why it should not continue in the circumstance. And that's why I ask your leave, please, to finish with a few more simple bullet points on this point. But it's very simple. These are procedural issues. The ex parte hearing, they presented Nick Marsh. Nick Marsh is entirely unqualified to speak about any U.S. law. Nick Marsh, which is in Index 41, he relies on U.S. colleagues for paragraphs 9, 51, 59, 60, 68, 71, 72, 75, 76, 81, 82, and 10 others more. That is the definition of hearsay. My good learned friend also is equally unqualified under U.S. law. Now, litigation privilege is one thing, but that does not mean you have a right to say, I spoke to my colleague over in America and he told me things. And as a consequence, I'm going to repeat them in my affidavit. Because if his affidavit is wrong, if it is false, what's the consequence? What's the consequence for a false affidavit presented before Your Honor confirmed to be false by another claimant witness, Mr. Brzezinski, himself confirmed that Marsh's statement was false. Now, that creates a bit of a conundrum. Your Honor relied on a false affidavit to give relief. I know that's a serious allegation. I'll back that up. Don't worry. I'll back it up with the citations. And Your Honor will agree that at least on a prima facie basis, it's a problem. But at a minimum, it's hearsay. So then you have Nick Marsh relying on hearsay from his colleagues. Nick Marsh repeating the hearsay to my good learned friend, who repeats it to Your Honor. Your Honor, of course, believes that it's proper. There's no reason to believe there's a violation. And so Your Honor does what is normal in a court and believes it, and is basically led by the nose through the improper presentation of evidence that is false. Now, I'm not sure that that should be permitted. And given the fact that I have some experience with freezing orders and the ever increasingly low bar, it appears, on granting ex parte injunctions, it concerns my client, and it concerns me as far as a discharge. Because if one can misrepresent facts to the court to obtain it, and then furthermore obtain paragraph 27, which is to take the information out of the jurisdiction.
Mr. McNutt, I'm going to interrupt you for a moment to remind you, I'm going to permit you to continue this speech for a little while, but I ask you two things. The first, in light of a comment you made just a few moments ago about discharge, to remind you that there is no application for discharge.
Right.
And whilst you have been very keen to point to things that are improper, it seems to me, in a circumstance where there is no application for discharge, you ought not to be making submissions about discharging or whether the order ought to have been discharged. The second thing I want to draw to your attention is that I've agreed to you making these opening submissions, but there must be a limit to it. We are dealing with certain applications. We've got limited time, and I want to get onto those applications as soon as we reasonably can. So what I'm going to do is to allow you a few more minutes to complete your opening submissions. In light of the way you've put these matters, I'm going to invite Mr. Montague Smith, whether he wants to say anything. In saying that, I am not suggesting that if Mr. Montague Smith doesn't reply, that amounts to any sort of acceptance of everything that has been said. But in the circumstances of what has been said, I will invite him, when you've finished, to whether he wants to make some brief comments or not. So please continue, but please make your remaining comments as short as you can.
Thank you, Your Honor. I think that's just a misunderstanding on a presentation. I apologize. When I use the term discharge, I use the term in the sense of the set-aside application, because a set-aside application, should you prevail, does discharge. And as a consequence, I'm not speaking capital D discharge, but lowercase d discharge in the sense of that. So if I do that again through the hearing, that's what I mean, the set-aside, and I apologize in advance. The reason I mention this is that instead of claimant understood the problem with the ex parte hearing and then submitted an affidavit, from Mr. Brzezinski shortly after the ex parte hearing to try to remedy some misstatements in Marsh. That was the purpose of it. And that demonstrates that once they got the relief, they realized, oh, we might have a little issue here when we get back to the return date, so we're going to try to remedy it. But that's a little bit too late. And if you look at it, and this is in the circumstance where I think it's arguable, should claimants be allowed to present any arguments today or tomorrow when they have admitted a clear and express violation of your paragraph 27? They are in contempt of paragraph 27, and Nick Marsh has committed perjury. an additional.
Where have they admitted that, Mr. McNutt?
They have admitted that. Thank you for that question. The collateral use application was submitted on the 21st of June. That is referenced in Nick Marsh's first witness statement. That is in index 41, or no, 51, excuse me. And then you have the directions hearing transcript, which is index 12. And subsequent to that, evidence is submitted on the 7th of July as referenced in Kreminsky's witness statement, which is index 65. And if we go to
sorry, when you're referring to index, do you mean
the bundle? Forgive me. The bundle is listed both with index and bundle page. I'll give you the bundle page in just 1 second, please.
Well, the index. The difficulty I have, I'm looking at the bundle that is. Not sure we're looking at the same thing is my concern. I have got the hearing bundle for return date, 31 July, which is some 9,306 pages. Is that the bundle that you've got?
Yes, Your Honor, 9,306 pages.
Okay.
And when you click on the bookmarks they've cited, and there's a print, they have a print of, or let's say a schedule of an index that they've attached. And in that index, what I do is I refer to the index number, which is the document, for example, Nick Marsh 1, and then I go to the bundle page number inside that 9,306.
Sure. So I've got number 12 is the transcript of the hearing on 25 June 2025.
Yeah, you should please go to index 65, which is Kreminsky's witness statement, please.
Right.
And that statement, the date of that statement is quite relevant because when we look at his paragraph 167.
What page is that on? Do you know?
One moment. Yeah, 1 second, please. I'm just pulling up the page. 6648. 6648. Oops, 1 second, please. You will see that they filed the motion to stay on the 7th and exhibited Marsh 1, Marsh 2, and the order and the transcript from the ex parte hearing.
I'm sorry, Mr. McNutt, I'm on page 6648, which is...
At the bottom, paragraph 167, please.
Yes, 167, yes.
Which continues to the following page. And here, and I just refresh our memory on the dates, So we've got ex parte 20th of May. We've got collateral use application to vary that order on the 21st of June. Then we have a 25th of June directions hearing, and we have a 7th of July submission referenced in paragraph 167, where they admit they have supplied Marsh 1, Marsh 2, the review order, and the ex parte transcript. Interestingly, not the 25th of June transcript I might mention, which they had, because the hearing was 2 weeks before that. So they don't even complete the record. And they say they had relied on the documents, so that's a problem. That's number one. And number two, they represent to you that they wanted the court to have the full and proper picture, meaning that they wanted to complete some missing information. But when they do that, they don't supply the 25th of June transcript. So even their claim to properly inform the U.S. is nonsense. It's just nonsense. Because Your Honor had decided to determine the collateral use application to vary effectively paragraph 27 today. Instead of waiting for that, and paragraph 27 is quite relevant, it says, permission is granted to use the documents and information from these proceedings. for 2 limited events, not in foreign proceedings. Definitely not in foreign proceedings. And then when we go to the undertakings, you'll find my good learned friend will argue, well, don't worry, the undertakings don't cover that. So don't worry, there's no damage. Well, what that would mean is that when they obtained the relief in paragraph 27 from you on an ex parte basis, and they presented the draft of the undertaking, which I'm sure Your Honor felt was a full, I mean, you thought it was complete. You didn't think it would be incomplete. That would make no sense. So you relied on the presentation that the undertaking would be complete to protect the defendant from the matters in the order, since that is the purpose of the undertaking. And you did not feel the need for security for cost or fortification, which is understood. And instead of actually respecting Your Honor and this court, claimant simply said, well, we don't really like that Judge Lemiere decided to hear it July 31st. By the way, we wanted to hear it in October anyway. We're going to ignore all of that, and we're just going to file it when we want in the U.S. court. And, you know, court be damned, procedure be damned, order be damned. It's irrelevant because we will do it. Might makes right. So now we have claimant in brazen contempt of your order, which begs the question, should you let them make any arguments in these proceedings in violation of your order? It's a self-declared violation. We don't need hearings. We don't need to have anybody debate contempt. They are in contempt by their own admission. On the other hand, Byju Ravindran is not in contempt. So I would like, please, for you to consider as a preliminary matter, are they even allowed or are they debarred? And if they're not debarred from making arguments, I'd like to please understand why they can do that and what sanction should be proper for that violation. Because, of course, we did not make a separate application for sanctions for violating your order. This is the first day that we have an opportunity to tell you these things. The first day we can inform you, hold on, we asked them to remedy that. We asked them to withdraw the information from the U.S. proceedings, and Quinn Emanuel told us no. That's even worse. We don't appreciate the lack of respect for the court. They took your order then, and you've seen this flub up the last couple of days on this draft letter from the DIFC court, or the Dubai courts to the DIFC court, asking for a letter. That is a direct consequence of your paragraph 28, which again is supposed to protect the defendant. It's okay to go on shore, not a problem. However, when they went on shore, they presented in their application to the Dubai courts that it was a permanent. They did not tell the Dubai courts it is an interim ex parte injunction with a return date June 25th. The application to the Dubai court merely said, here's the order from the DIFC. That order is to pay $540 million, block all his bank accounts, give him a travel ban, and he has to pay $540 million. Now, that creates a bigger problem for us as a preliminary matter.
All right, Mr. McNutt, I think I've been fairly indulgent in this so far, in that we haven't yet got to the applications. Mr. McNutt, please don't talk over me.
Apologies.
I'm going to let you continue until 10 past 11, and then I'm going to ask Mr. Montague Smith if he wants to respond. So please make the best use you can of these remaining minutes.
Thank you, sir. I pointed out 2 express violations of your order. Those violations are severe. The second violation, by improperly registering your order, has caused Byju Ravindran to be unable to return, because when they obtained the order, they failed to mention he wasn't even in the country. They obtained the order knowing that he was only in the country as a non-resident, that he was here to help tend to his father who has cancer. His son is here. As a consequence, the bank accounts are frozen. Fortunately, as we've indicated, he has no money in the jurisdiction because he doesn't live here. So the bank account isn't really the problem, except he can't put money in the jurisdiction to to pay his living expenses because it's blocked. And if he puts it in, it won't be released. And his travel ban prevents him from returning. It doesn't prevent him from returning, excuse me. He's allowed to return, but then he's not allowed to leave. So
I'm sorry, can I just ask you to explain to me, as I understand from the affidavit he has filed, he doesn't have any money anywhere else. What money is he going to put into the local accounts? He doesn't have any money anywhere else, does he?
No, well, Your Honor, I think that that's an incorrect statement.
Right.
I think that what is failed to be understood, but has been said in multiple fora, Mr. Byju Ravindran is required to borrow money.
Yeah.
Borrowed money is not an asset. Borrowed money is not disclosable as an asset. It's not an asset. It's borrowed funds. It's a debt. And Mr. Byju Ravindran is obliged to use that money. He can't use the money in the jurisdiction. For example, he has to register his son for school.
Well, I'm sorry. I want to interrupt again, Mr. McNutt. It's probably not the time to get into that argument. But I must say, without having you explain it to me, I would have thought it goes this way. If he has borrowed money and received money as a loan, so that he has money sitting in a bank account somewhere, then that would be caught by the terms of the freezing order, notwithstanding that corresponding to the asset is a liability being a debt. But that's perhaps for another day.
Well, I would have to say that an accountant, and me being an ex-regional director of Deloitte & Touche and Ernst & Young, I would have to respectfully say, Your Honor, that is incorrect. You cannot reclassify an asset, a debt, as an asset. It's a debt. It's not an asset, and any balance sheet will not record it as an asset. It's not an asset.
Sorry, I don't understand that at all, Mr. McNutt. Perhaps we're at cross purposes. If Mr. Ravindran had borrowed, let's take a simple example. If he borrowed $100,000 from a bank and he then deposited it in another bank account somewhere, that $100,000 in Bank 2 would be an asset, and the debt he owes to Bank 1 would be a liability. On any balance sheet I've ever seen, they would be recorded respectively as assets and liabilities.
And should you do that, I'll give you an easier example. I'll let you borrow my car. Is it your asset if I let you borrow my car on your balance sheet? No, it's not. It's my car.
I don't think we're talking about cars. We're talking about money.
Depends. We got to talk about everything because the freezing order doesn't distinguish between cash and cars, Your Honor.
All right, let's. I've perhaps taken you down off a track that's wasting time. Perhaps if you get back to finishing your submissions.
Well, I think you've highlighted a really good point, though, because this is not debtor's prison. Your country and my country, respectively, oppose the English laws precisely for a debtor's prison, particularly when someone's not in the jurisdiction. So there is absolutely no doubt Mr. Byju Ravindran has a right to have monies for his normal living expenses. That's well established, even relying on Pugachev, who I represented in his freezing law. So I'm not worried about justifying reasonable living expense cash. I am worried about an improper application for an ex parte order that has been disrespected and claimant is in violation of two provisions of your order. And therefore, the question that I ask you to consider is, we would like you to determine if claimant is permitted to make argument being in contempt of your order. Because they are, it is self-declared contempt. And that should not go without sanction. It's remarkable they are seeking collateral use when they themselves have violated the collateral use. It's insane. It makes no sense. And we find it a disrespect to the court. The court should be offended. And that's why we're asking the court, if Byju Ravindran doesn't respect your order, we would expect you to sanction him. I would expect equal treatment. Here, claimants have violated 2 provisions and damaged the defendant. He is expressly damaged by this violation. It's not some theoretical damage. He's damaged. He could not see his father last week, who had surgery for his cancer, because he could not come back in the jurisdiction. He called me in tears on the phone. What am I going to do if my father dies? It is inappropriate. They have taken your order, have misrepresented to the Dubai courts that it is a permanent order in order to obtain a permanent travel ban on the defendant 1. And that violation of your order cannot go without sanction. And I simply don't know what to propose, but I would ask you to consider it at the break and let us know, please, what you feel is appropriate. You might want to consider that after my good colleague replies. You've given me until now. I'm going to be quiet because we've agreed to do that. I thank you for the time, and I thank you for the indulgence. Thank you, Ron.
Thank you. Mr. Montague-Smith, I'm going to give you an opportunity to respond if you want.
Thank you.
But I want to make it quite clear that in doing so, I'm not, I don't wish to give the impression that if you don't respond, that amounts to any sort of acknowledgement or admission.
That's very kind. Thank you, Your Honour. The first observation I'd make is that those are quite extraordinary submissions. And Your Honour's an experienced judge, both in this court and in other courts. What you've heard is Mr. McNutt giving evidence about prejudice that he alleges, telephone conversations he had with his client. You've heard him paraphrasing evidence in tendentious ways, but not actually show you anything apart from one passage of Mr. Marsh's witness statement. I will deal with that because it's a serious allegation, if I may. Just taking it broadly in the order that he started with. I mean, I don't know whether you want me to address you on the page limits.
No, I don't want to hear about that.
I don't know whether you want me to address you on the relevance of Australian law. To be clear, we're not pandering to Your Honour, and Your Honour knows full well the authorities in this area in cases like TIG and so forth.
Mr. Montague-Smith, I have experience of sitting on a case where you were doing the opposite of pandering to Australian law, where you informed the former Chief Justice of Australia that perhaps Australian law was not mainstream, but...
only in one respect, and I will never live that down. And in mitigation, I remind Your Honour that I am also part Australian, but that feels like a weak defence. I just... Firstly, my own friend says there's been intentional misleading of the court, and that is a criminal offence. So he's accusing, I don't know who, of crimes. Those are very serious allegations. Those should not be made unparticularised in this way. None of that has been asserted. That there's a raft of new full and frank disclosure allegations, and we'll deal with those in due course. Those are, and I use this word advisedly, a disgrace, the way those are put. That's not language that I've used in this court before, but that is the position. They're simply factually false about what happened in this court and about what happened in other places. We'll come on to those in due course. I won't take your time on those right now. My own friend says, well, Mr. Marsh is unqualified to speak about US law. Your Honour will be fully aware, no doubt, of the Fidel and Felicia case. We've got it in the bundle. If you want it, it's at C245. That's the Claimants Authorities 245. That endorses the international approach to non-DIFC law and says that you can take it by submission. So that's all. Mr. Marsh was simply drawing Your Honour's attention to the relevant principles and indeed exhibiting the supporting materials. So to suggest that he's giving false evidence or trying to mislead the court is completely unsubstantiated, unsupported, and another allegation that should never have been made. It was said that Mr. Hranitzky's affidavit that was put in after the ex parte hearing. You'll recall there was an affidavit that came in shortly after the ex parte, and it was said, well, that was an admission that things had gone wrong and an attempt to remedy things. It's nothing of the sort. You may recall, and you'll see when you look at it, What happened was that before the hearing, there was an ex parte attempt to release information that was covered by the prohibition in the United States on the use of certain information, and it covered the deposition that Mr. Ravindran had given in relation, in part, to his assets, and we put that before you and said we can't show you what's in it, but we can tell you, we think fairly, what they are likely to say about their assets, including Mr. Ravindran. What then transpired was, in the course of the application to try to release the prohibition, information had been leaked, and what that meant was that, contrary to the way that we put the case to Your Honour, we weren't going to delay service. So information had been leaked out from the US court to the lawyers of one of the defendants, and that had put them on notice that this application had been made, and that meant we had to change course. So whereas before, the proposal which Your Honour was satisfied with was that we would get the order, take it on shore, enforce it, and then serve it, we had to just serve immediately. And the result of that, apart from anything else, is that there's been a window of time where the defendants have known about the order, been bound by the order, but that has not actually resulted in the accounts being locked, because there was a period of time when that wasn't. But that was the purpose of the affidavit, was to update the court about that. Not to. There's no admission in there of any problem in relation to the application, and certainly I make no admission in relation to that. Your Honour made the point that this is an application. There's no application for discharge. There's an application to set aside, but it relates only to the proprietary order. So the issues in relation to that are confined to those. Just make that point. Then there are two complaints that are made. One we don't really understand, but one is quite clear. What's said is that there's a, quote, self-declared contempt. And can I just take a little bit of time to deal with that, if I may, because that is also a false allegation that is being made. So if I can take you to the freezing order first, if we go to page 31.
Yes.
I'm sorry, I'm having trouble with my technology now, but there we are. So this paragraph 27 is the paragraph that Mr. McNutt relies on. Now, paragraph 27, he says there's been a flagrant breach of paragraph 27, but when you read paragraph 27 of the order, it doesn't impose any restrictions at all. It gives permission to the parties to use documents and information in various proceedings. Now, the reason that is necessary is because of the collateral use restrictions that appear in two places. One is in the rules, and we'll come on to this in the collateral use application, but the rules refer to the use of documents received and witness statements received from the other party. So they don't cover your own witness statements, because those are your own documents. You can do what you like with your own documents. Then in the Schedule B to this order at page 34, you will see what additional undertaking was given, and this is in standard form, save that it gave permission to use it in other jurisdictions, and what it says is the applicant will not, this is, sorry, undertaking 6.
Yes.
The applicant will not, without the permission of the court, use any information obtained as a result of this order for the purpose of civil criminal proceedings, other than for, and then identifies the other claims. That's the operative restriction that the claimant was faced with. And so the documents which were provided to the US court were the transcript of the ex parte hearing, the order itself, and the first and second affidavits of Mr. Marsh. Now, none of those were information obtained as a result of the order. That undertaking is aimed at controlling the use of, for example, asset disclosure. And so there is no arguable breach of this order by my clients. My learned friend tries to rally and he says, oh, well, that Your Honour relied on the presentation that I made, that somehow this undertaking gave wider protection. That is unsupported assertion. This sort of order and the structure of this sort of order is in standard form. And the amendments to the standard form were brought to Your Honour's attention. And they are simply the permission to use these sorts of documents in certain other sets of proceedings. There's no other ordinary form of protection that applies, for example, to transcripts, to witness statements, to affidavits, and to orders. And so that allegation is simply untrue, what is being alleged, and it is untrue to assert that it is self-declared, that there's any sort of admission of a contempt. The context for all of this makes things worse, and we'll come on to this again in the collateral use. The reason these documents were provided to the US court was to correct a false account that was being given of the proceedings that took place in this court. So two things were said in the US court. One, it was told, the US court was told that no cross-undertaking in damages have been provided in these proceedings. And second, it was said that I had implied to Your Honour that the deposition given by Byju, that in it he had disclosed substantial assets in Dubai. That's what the US court was told. And you can see that, for example, at page 7448. This is submission made to the US court on behalf of Mr. Ravindran. And the second, do you see the second full paragraph towards the bottom?
Yes.
The debtor obtained the 21st May order, that's Your Honour's ex parte order, based on its representation that Ravindran has substantial assets in Dubai. That is true. That was our case. The debtor did not withdraw its representation, even though it learned during the Ravindran deposition on May 15th, 2025, that Movement does not in fact have substantial assets in Dubai. And this is the bit. Instead, at the May 20th, 2025 hearing, the debtor's counsel referenced the Ravindran deposition testimony and assured the DIFC court that all of the debtor's statements about the movement's assets were fair. Thus, rather than withdrawing its then debunked representation regarding substantial assets, the debtor misled the DIFC court into thinking that the Ravindran deposition testimony supported the claim, as with the misrepresentations regarding the 14th March judgment. The debtor's disclosures on asset issue were neither full nor frank. Now, that is quite false, and I can show you that very shortly. If you go to page 62 of this bundle, you'll get to the transcript.
134, para 134, Nick Marsh.
No,
excuse me, Your Honor.
No.
You asked me not to do things that I'm going to do later. He's basically pleading his collateral use application right now.
No, well, I'm not. I'm responding to an allegation of contempt.
Mr. McNutt, the view I take of it is this, that you made a serious allegation that there was a self-declared violation of the court's orders. It's that Mr. Montague Smith is responding to, and I will permit him to do that.
Thank you. So we were at page 62, and this is the context. So this is my ex parte submissions to Your Honour. In the middle of the page, we say this, I said this. Firstly, do you see in the middle of the page that there were a couple of depositions taken in the United States, and those were depositions of Byju, who I will come on to explain, and also Mr. Morton, who was associated with one of the company's camshaft who received the funds. And I say, I cannot tell you what took place in those depositions because the transcripts have been designated as confidential, and there is a confidentiality regime. Mindful of our duties of full and frank disclosure, we happily consider that despite that, we are in a position to give you a fair picture of what the defendants are likely to say about their asset position. In part, that is because, and I'll give you the detail of this in due course, last night it came to light that Byju and Divya, two of the defendants, have issued or published a podcast And in that podcast, they deal with, in part, what they say is their asset position. In short, they say they have nothing. And despite the fact they live in the mansion that is being funded by other people, and I will come on to the detail of that, further down the page, my submission, on the second line of my submission, I say, I think what is important is that we let you know what we understand to be their position, whether we agree with it or not. We do not agree with it, but it was important to us to make sure that you had a fair presentation of what they would say or what they are likely to say about their assets. We could not do that by showing you what Mr. Byju has actually said in his deposition, but we can, to some extent, at least tell you what we think the defendants will say about their position. In short, as I say, their position looks like it's going to be, we do not own anything, we've got nothing left, and you cannot take anything from the fact that we live in a mansion and we have staff because it is being paid for by other people. So that is the position. We say it's not credible, but there it is. And then I ask you to read the affidavits. So the allegation that was being made in the US, and it's maintained before you today, is that I misled you by implying that Mr. Ravindran had said in his deposition that he had substantial Dubai assets. But you can see from this transcript that we said quite the opposite. And so that is the reason why we sought to introduce that into the US proceedings to correct what had been asserted about what was happening in this court. And so that makes it all the more egregious that they are trying to prevent us from telling the US court the truth. And they are trying to do that by making specious allegations.
All right. I think, Mr. Montague-Smith, you've made the point that you do not admit any misleading of the court, no self-declared violations or contempt. I think you've made that point. Unless there's anything else, I'd like to move on.
Understood. I will then hold my tongue on the rest of it. Thank you.
All right. Well, thank you. Mr. McNutt, so far as the matters that you put to me, I'm not satisfied that there is a self-declared violation of the court's orders or that there is an admission of contempt. It is, of course, open to the defendants to bring an application for contempt if they are so minded to do. I intend now to proceed with the applications that are before the court today, starting with the jurisdiction argument. So far as timing is concerned, it is now trying to make the adjustments. It is about 11:26 Dubai time. I propose that we should take a break at approximately 1 p.m. I will leave it to whichever counsel, if it's you, Mr. McNutt, if you're addressing at that time, I will, or if it's Mr. Montague-Smith, I will leave it to counsel to pick an appropriate time for a break. But we'll need to take a break at about that time. Perhaps I should also check. I think we've been, we took a bit of a break. I know the stenographers, I think, require no more than about 90 minutes before taking a break. I think we'll be all right if we keep going till, or perhaps not. Perhaps I can ask the court officer to let me know if we get to a point where it's necessary to take a break, because the stenographers have been working as long as they can. Subject to that, Mr. McNutt, I'd invite you to commence with your application submissions, starting with the jurisdiction application.
I hesitate to interrupt, Your
Oh,
Honor.
yes, thank you.
Can I just confirm with the parties whether a transcriber is currently on this call?
I don't think we have one.
Oh, okay.
I think not.
All right. All right. Well, thank you. Ignore all that I said about that. We'll take a break at approximately 1 o'clock Dubai time, and whichever counsel is addressing at that time, pick a suitable time. All right. Mr. McNutt.
Thank you, Your Honor, and thank you for your understanding. I mentioned only that it is unsurprising that you are not convinced on a self-declared, given I had no right of reply, so we will reserve that right for any motion, because obviously we did not intend to plead a full motion before you today, but I will deal with that later.
Okay.
So when we deal with the injunction, if I can take you through that wonderful guide that's called the skeleton, my suggestion, I'm going to try to stick kind of near that. I'm going to have to move into one other section regarding service that my good learning friend and I discussed before, but I just want to make sure that it's clear, as referenced in paragraph 3, that the burden lies on a continuation application for my good learning friends and the plaintiffs. There is a lack of jurisdiction, as we mentioned in paragraph 4, for one of jurisdiction, material non-disclosure, and inadequate undertakings, which we will address. I'll address material non-disclosure last, frankly. So we're going to try to keep this as close to the litmus test of jurisdiction as possible and not get into the subjective contentious elements until later. And the reason for that is if I prevail on the first two, I don't have to get into full and frank today, and we can move forward more quickly. So the proceedings here contain no assets, events, or parties connected to the DIFC. When I say no assets, obviously somebody visiting here on holiday to help with his father, who is a non-resident, I don't consider that to be assets in the jurisdiction. I consider a local bank account with less than $10,000 as a matter of convenience for bank finance charges, et cetera, because of what's necessary, given the fact that camp's treatment is prolonged. And I appreciate that on a formal basis, it is an asset as a bank account. And we'll talk about the utility of that. And as you see, Mr. Ravindran is closing that account. It has no utility because, frankly, he can't come back anyway with a travel ban. So there's no point in paying maintenance charges on an account that has no utility. Now, when I get specifically to, and I'm not going to go through paragraphs 1 through 11 in detail, the factual and procedural background, I just would like to clarify something for the court, is that the, the debate we're having about whether or not the partial summary judgment was in fact final or not, or enforceable or not, I want to mention that from the ex parte date until now, certain material changes have occurred, right? So at the ex parte date, there was a motion to amend that was pending that Peter Van Tol and Mr. Haninsky talk about in their various statements, but that's an important issue. Once that is resolved, then you move to the procedural right in the United States to file a motion to appeal, which is referenced in paragraph 22 and 23 of the skeleton, as well as paragraph 21 showing the timetable. And it's important to note that all of those events occur after the ex parte hearing. So again, it's a question of, at the time of the ex parte hearing, was there in fact a partial summary judgment capable of being recognized in the DIFC? And I'd like to focus on that moment in time and not be distracted later.
All right. First matter I want to ask you about, Mr. McNutt, is
please.
You're addressing the question of whether the judgment or order was a final order. Is that right?
No, I want to get the chronology right, because it's at the time of the ex parte application, the difference in the two parties is one party says it's final, the other party says it wasn't final. However, as we proceed through the arguments, it will be clear that it wasn't final by claimant's own admission, and that becomes relevant. So
when you get to it, I'll in a moment be quiet and let you get on with the factual background. But when you get to it, you're going to have to address me on this point, and that is, the question of whether or not the judgment is final is a defence to the application for recognition and enforcement. It's not a matter going to the jurisdiction of the court to hear the application. So when you get to it, you can address me on that point.
Yeah, I think that's a very relevant point. And I appreciate the difference between a merits argument on standing, on the standing of those merits versus the right of the DIFC. I mean, as you know, it's accepted in the DIFC that a final judgment is a different test as far as whether or not it can recognize, right? Yeah. So we just have to go to the specific facts of the case, and so I'm just directing you to paragraph 27 of the skeleton, just so we're following along. And I don't like it when counsel bounces around, so I'm just trying to flow through the skeleton to give you some guidance, and that's why I've shared with you those prior paragraphs. Now, what we have here is a situation where, and quite importantly, there are requirements under Article 31.4 of the DIFC courts law where we argue that it permits enforcement of foreign judgments only where there's an executory formula, okay? And when we look at, one moment, please. I want to make sure I get the right citation. I'm going to take you through the law first, and I'm going to come to the fact of the executory title.
Once again, that's not a matter that goes to jurisdiction, is it? That's a merits defence.
That's debatable, and that's why I'm going to assume you haven't predetermined that. That's debatable, and as you've asked me to do is you've asked me to address that point, and I will. Yeah.
Okay.
But
when you get to it, I don't want to take you out of your course.
No, I'm pretty flexible on these things, Your Honor. So we're good with that. Okay. And if I can easily answer it, I'll answer it. What I'm trying to highlight is there is in paragraph 33, we lead to this Nadil decision, which appears to be quite relevant for both parties and for the court. So it's quite relevant that the Nadil decision makes it very clear that there must be a direct link between the foreign judgment and the DIFC. And it further states, as referenced in paragraph 34 and paragraph 22 of the order, or the judgment, that the foreign judgment must be against an entity within the DIFC. And it is accepted by the claimant in paragraph 116 of their skeleton that Mr. Ravindran is assuredly not an entity within the DIFC. There's no doubt about that. And it's agreed between the parties that he's not an entity in the DIFC. And so then you get to the fact as to whether or not the judgment can be registered in the DIFC. That's wholly different than Ravindran being in the DIFC. And we need to show, according to the court, that in that particular case, the claimant failed to show there are existing or potential assets within the DIFC in order to create that direct link. Now, even in the schedule of the freezing order, there's no attempt to claim there is any asset or potential asset in the jurisdiction of the DIFC. None whatsoever. The only asset they reference, without any evidence, they just say something, is there's an unspecified stake in Schedule C, 1, in a freezing zone company registered in the UAE. And by admission, it's not in the DIFC. So claimant's own evidence at the ex parte order fails to establish any direct link in the DIFC. And furthermore, today, after all of their investigations, they also fail to provide any direct link within the DIFC. Now, when I'd like to take you in that respect to bundle.
I'm sorry to interrupt again, and you might be going to come to this, but I think you'd be aware that the claimant's answer to the point based on the Nadil judgment is that the judgment was wrong. It's the subject of appeal to the Court of Appeal. The Court of Appeal found that the contrary argument is, I think they said, strongly arguable, but didn't finally decide it because that was left for an inter partes argument. But the point being that I think it's in their submissions. If not, perhaps I'm just anticipating what Mr. Montague-Smith is going to say, but I think the claimant's position is that the decision of His Excellency the Deputy Chief Justice in Nadil is wrong.
Well, I'm a big believer that proverbs matter because they prove themselves over time. So I'm going to throw one at you called what's good for the goose is good for the gander. Now, if claimants want to say that Nadil is wrong and they don't agree with it, and it's under appeal, then they also have to say that the partial summary judgment that we say is wrong and is under appeal, we should have the same probative value as to our argument as their argument. So the last time I checked, their other argument for the partial summary judgment was there's no stay on the partial summary judgment granted. And there's no stay, as far as I'm aware, on the deal. So I again would respectfully say that what is good for the goose must be good for the gander. And I would ask you to remember that as we proceed through claimant's arguments. And I would further mention that the submissions related to the Court of Appeal have to be ignored because the Court of Appeal decision isn't out. And as a matter of law, there is a decision with no stay. And the decision says there must be a direct link. And if claimants wanted to bring their ex parte application after the Nadil appeal was issued in their favor, possibly, they were welcome to do so. But they elected to bring it now. So they got to live with how it is now. And they can't superficially predict what the law might be in the future. And so I would suggest that those arguments in any event should be tossed out of this discussion, no different than claimants saying, well, it's under appeal, therefore you should believe that we will win. Well, defendants have a little different slot because the burden is not on defendants to prove they have a good and arguable defense. The burden is with claimant to prove they have an arguable case, not for defendant. So here, the burden still rests with claimant, unfortunately for them. And Nadil clearly says, direct link, and I'm in paragraph 38 now, if you want to see in the skeleton. It says, preferable for the DIFC courts with a question of jurisdiction is reasonably arguable to get a return date for inter partes hearing. So again, they don't say good and arguable case. They say reasonably arguable, which is a concocted definition with no support with precedent at this point. And therefore, in the absence of a definition of reasonably arguable, and unless I'm mistaken, you're free to correct me, Your Honor, if there's reasonably arguable precedent test after Nadil during the appeal, but I don't believe there is yet. It means that claimant must reasonably argue. And that test, in the absence of another, should rely on the precedent, good and arguable case, until someone determines reasonably arguable is less than that case. And I don't believe there's case law indicating a distinction between reasonably arguable and good and arguable case. I believe that the test is not yet in the jurisprudence. And in any event, they have failed to present a reasonably arguable grounds to say why it should be relevant for them to ignore the fact that they are representing to the court that they have a final judgment, right? They're representing that the partial summary judgment is final And whether or not that's a test they need to achieve or not is a different question, Your Honor. But they've said it's final. They could have very easily said it's not final, but we still want to enforce it. Fine. That's not what they said. They said it's fine. And there's a consequence to that. Now, when we look further at the Court of Appeal decision that we're discussing, it's not available possibly even to rely upon at all, even if it is public, and even if it does say what people are supposing and speculating, because it's not conclusive under Article 9D, read together with Article 18 of the new judicial law. So even if that were the case, as claimants would put forth, A, it doesn't exist, B, there is no stay, C, Article 9D read with 18 still creates a problem for them. The issue concerning whether or not
I don't know if you want to address it or not, Mr. McNutt, but I think the claimant places reliance upon Article 31(4) of the court's law.
I will come back to that. I've got that a little bit later in my submission. Thank you.
Okay. Okay.
If you give me 1 second, I just need a drink of water. 1 second, please.
Yeah, of course. Of course.
I just have really bad allergies, so if I say something, I'm sorry. Thank you. Excuse me. And I appreciate your indulgence, having just been instructed. The flow of my presentation is somewhat not as intended, so thank you for your understanding. I'd like to, I think right now I'll turn to something
I'm not sure. Oh, yes. Okay.
No, you're here. I'm sorry. I was just pausing to make sure that I didn't jump ahead of something. I'd like to address service quickly, because that becomes quite relevant prior to us discussing the arguments made by my good learned friend in the skeleton argument around paragraph 100, paragraph 199. So just, I think it'll be too confusing if I bounce all the way over to his paragraph 100 and back to this. So let's
just
go
explain. Just explain to me, where does service fit in the argument?
So there is improper and incomplete service because of the fact that the transcript of the ex parte hearing demonstrates that
but that doesn't go to jurisdiction, does it?
Well, it goes to the jurisdiction of your jurisdiction at the ex parte hearing and then serving that order.
So you're talking about service of the May 21 or May 20, May 21, the freezing order and the proprietary injunction.
Correct.
Well, but the court's jurisdiction to grant those orders is not affected by service or non-service or improper service of those orders, is it? It might, that's a question. If we're concerned with enforcement of the orders, then service of the orders would be relevant. But service of the orders is not a matter that goes to the jurisdiction of the court to make the orders, does it?
I would say that the jurisdiction of the court to grant the order was based upon relevant omissions concerning and misstatements concerning the assets of defendant one, the residency of defendant one, and the finality of the partial summary judgment.
All right, well, you might come to that, but I was just asking about service. Can I forget about service? Service isn't relevant to jurisdiction, is it?
I had agreed with my good learned friend to tackle this in the jurisdiction, so I'm just trying to get it out of the way promptly.
What is service relevant to?
So service, there's no utility in the court granting an order if it's not properly served. Do we agree with that?
No, I don't understand that. If the making of an order necessarily comes before service of the order. I don't know if there might be an argument that goes something along the lines of there's no utility in making an order because it's impossible to serve it, but that's not the point you're making. You're talking about there having been inadequate, improper service of the order. But that's simply not relevant to the jurisdiction of the court to make the order or to make another order. Service is relevant.
I don't disagree with that. That's fine. I will address service in the context then later when it comes to allegations of non-compliance or issues related to the order.
All right.
Okay, that's fine. That's fair. Thank you.
Okay.
Well, I pondered that question. If you can give me one moment, please, I just want to reshuffle my papers, please.
Of course.
Thank you.
Mr. McNutt, please take your time. I would rather you pause and take your time and get your tackle in order than to press ahead and be disorganized.
Thank you.
Yes.
I think possibly the most effective use of time would be, in fact, excuse me, to turn to claimant's skeleton, because then I can just address my good learned friend's point on, just spot on, and knock his defense, frankly, out of the way. And then we can just expedite matters.
All right.
And he starts his jurisdictional challenge on his defense on paragraph 96. There's some earlier referencing paragraphs that I won't really focus on right now, except paragraph 14. And the reason jurisdictional challenge is relevant is you'll see in paragraph 19, he just states what he claims to be a fact, that he was served by email on the 21st of May, and that's why the service issue came up first, and I just needed a moment to recall that. Now, it does beg the question, if the court was misled to grant service by email at the ex parte, that we think is relevant, and I would just ask Your Honor to direct me, when would you like me to address that?
I'm not sure which application. I'm not sure which application it is relevant to. It's not relevant. It seems to me it's not relevant to the jurisdiction argument, or the set aside argument, or the fortification or security for costs arguments. It might be, I don't know, it might be relevant to the continuation argument. Not altogether
clear. I think that's right.
But
yeah, I think you're right. Continuation. Yeah. I think that if we assume that an order should not be continued if it was obtained by misleading the court in the first place, then I can address it in continuation. That's a good suggestion, or observation, not suggestion. That's fair. So I'll do it then after my good learned friend presents his continuation. I'll do it in a defense. Okay, thank you for that. So when we look at the issue here, the arguments against the jurisdictional challenge are frankly quite limited. They're only, from their side, paragraphs 96 through paragraph 117, which should allow us to kind of galvanize our discussion here. Now, we do not agree that defendant one is raising substantive defensive now, that's paragraph 99, where claimant is alleging that if he raises substantive defenses now, he should be precluded from reviving the same arguments later on a discharge application. I don't think that's fair. If they want to make that argument at the time, they're welcome to do so, but not now. That's premature. There is a set-aside application, and that's...
Well, the jurisdiction argument is addressed to the freezing order, is it not?
Well, it's also addressed to the preliminary injunction. It's both. So
you mean the proprietary injunction?
Precautionary injunction, yes.
Okay.
So, but I'm focused now on this paragraph 100.
Well, one approach I might take is to consider whether defences on the merits go to the question of jurisdiction. And if they don't go to jurisdiction, then simply not decide them. That is, let me take the question of the final order. I think it is common ground that it is a condition for the recognition and enforcement of a foreign judgment that the judgment be a final judgment. But let me just say one view, a view which provisionally has some appeal to me, is that is not a matter that goes to the jurisdiction of the court to hear the application for, or jurisdiction to recognise and enforce the order. It is a condition which must be met for the recognition and enforcement. That is, and the argument that it was not final is a defence on the merits, but it's not a matter that goes to whether the court can hear the argument, has jurisdiction to enforce. Otherwise, well, perhaps I should leave it at that. Mr. Montague-Smith might want to take it further.
Yeah, no, Your Honor, I think, and I'm okay with us debating that even now. I think that's an excellent point.
It's a bit like, let let me give you an analogy, Mr. McNutt. It may be an argument, for example, that a defendant, a claimant brings an action on a contract, and the claimant and the defendant says the contract was never signed. Well, if made out, that's a good defence, but it doesn't go to the jurisdiction of the court to hear the case based on the alleged contract. So similarly here, I know analogies are often dangerous, but to try and illustrate my point, an argument that the judgment was not final may be a good defence on the merits when the court, if and when the court comes to hear the application for recognition and enforcement. But, might be put, it's not a matter that goes to the jurisdiction of the court to hear the application.
Do you mind if I follow up just
Sure.
a question on that to understand, please?
Well, so, I'll try. I don't want to be in the position of giving provisional views, but
it's again probably the French side of me where collegiality prevails in this because you're trying to get to the truth. So I think it's appropriate. Even if your provisional view isn't something I like, it's better to talk about it than not, right? It's okay. And I'm not saying I don't like it because I think I just need a clarification. So
yes,
if the judgment that would have to be determined is final or not final is subject to a different jurisdiction than this court, how would this court determine on a merits basis? To me, a judgment is final or not final is a matter of fact, not a matter of interpretation. And this court, the DIFC, might, and could be wrong. My understanding is this court takes the foreign judgment as a matter of fact. And so what we are debating here is not asking Your Honor to interpret, is it final or not? It's only to interpret the evidence before the court and the burden of claimant that as a fact, they must show it is final. I'm not sure what that was. And forgive me, I don't know what happened there. But I'm happy for the emphasis, for the dramatic pause on the emphasis on burden. But I think that if I take your example and say, okay, if it is merits, the U.S. court would have jurisdiction in this particular example on the merits. But as you conveyed it, it was if there was a case where one party says there was a contract, the other party says there's not a contract, and a different jurisdiction was determining that, that would be in aid of a foreign proceeding, similar to case 50 in this example, right? But here in case 51, it's presented as a matter of fact by claimants. And consequently, I think that assists the court to require claimants in the face of a challenge to the statement it's final to say, hold on a second, do we agree if it's not final, the court does not have jurisdiction? Because that's different than if it's not final, the court can't continue. And so I think those are two distinct questions. And our view is it was not final, and the court, as a consequence, had no jurisdiction to issue the order.
All right.
Yeah, and I believe the evidence.
So you're saying it goes to the power of the court to issue the order.
Right.
All right.
Right. Yeah, and maybe that hasn't been properly articulated, and I apologize for that. But I think that's the fundamental question. Was the order final of the ex parte represented as such by claimants? Yes or no? Is it final today? Yes or no to warrant a continuation? Separate question. Yeah. And if I go to the first question, which I believe is what is relevant, Paragraph 100 is important in claimant's skeleton. They talk about whether or not it has a fixed executory formula, and claimant puts forth in an agreement for that in paragraph 102 that Ravindran accepts there's no written formula as long as the foreign judgment satisfies an equivalent standard of finality under the foreign law from which it originates, which is the last part of the quotation in paragraph 100, right? That's the law. And I appreciate claimants pointing that out. And the dispute between the parties right now is, does the US law provide an equivalent standard of finality on that partial summary judgment or procedurally at all? Is there an equivalent under US law to the equivalent standard of finality from which the judgment originates? And if I just accept claimant's position that that's the test, because they say that's what Ravindran accepted in 102, so I kind of stuck with that, if that's true, then we just need to look at it and then look at paragraph 103, which it says the order does in fact contain a functionally equivalent. And this is really important because there's criticism from claimant that Peter Van Tol doesn't use the word functional equivalent. He calls it practicably enforceable instead of functionally equivalent. And I want to take you please into the bundle. If we go to bundle page 3067, please. Maybe I'm wrong. Hold on 1 second, please. One second. I just got to make sure I got the right citation. I think it's I'm sorry. It's bundle 2129. It is not 2129. 1 second, please. I have a typo somewhere. Forgive me. Thank you. So much for the dramatic thunder on this. One moment.
Are you looking for the summary judgment order? If you tell me what you're looking for, I can probably give you a page reference, Mr. McNutt.
You're on mute, Mr. McNutt.
Yeah, I was just asking because I know where I had it, I said it represented. But I'm looking for actually bundle 889. Thank you, my good colleague, for offering to help. So I'm just going to go somewhere first. This is the first affidavit of Mr. Marsh. And, you know, I'm a big believer that it's quite relevant how lawyers write documents. And the section here is called, it is expedient to grant the relief sought. Now, obviously, he wants to satisfy a test with that declaration of the preamble. And we go to 138, and I am well aware of my good learned friend's citation to the fact that you're allowed to use hearsay because of certain rules and things like that. But it doesn't mean it's not hearsay. It just means you're allowed to use hearsay. That's different than assigning the same probative value to hearsay as to someone actually qualified. It's not the same. So Peter Van Tol is actually qualified. Krenitsky is actually qualified. And Marsh is actually not qualified. And that was what I was articulating. And when we get to this motion to contempt issue later, which won't be today, you'll see why it is an express declaration. And it'll come out today anyway. And I'm pretty sure at the end of today, Your Honor will be convinced of what I did not convince him of earlier because of the facts that my good learned friend presents in his own skeleton, starting in paragraph 100. So when we look at 138, he talks about this concept of passporting. And this passporting is related to the functionality equivalent in Clay Skeleton 103. And when I look at that text, he says, I understand a judgment from the court can be passported into federal court districts in the U.S., not outside of the U.S., in the U.S., where functionally equivalent relief may be available. Okay, I agree with Marsh. It is functionally equivalent relief available in the U.S., which is his statement. That's good. Once any appeal has been resolved, as a matter of fact, there is a pending appeal. It's not resolved. So that means it is not functionally equivalent today with the appeal pending. That's a fact that we have no problem with, and Krasinski agrees with that. Peter Van Tol agrees with that. There is no evidence from anybody that we don't agree with that. So that's great. That makes the job for Your Honor pretty easy on that point because it's a fact. And then he says, once it's granted, the time to appeal expires. Okay, that's not the case because the appeal is pending, so that test doesn't. Or a finding of good cause is made by the issuing court, the latter of which I understand occurred in the U.S. And he cites the May 7th order. Fantastic. Let's go to that order, please, at 2129. At 3067, I'm sorry, because of Nick Marsh's bundle is different than the hearing bundle, 3067. So let's go to that order. Now, I mentioned this order was brought by BA, was brought by claimant, and it begs the question, if the partial summary judgment was sufficient, why bring this at all? Why did they even need this order if the partial summary judgment itself was sufficient? The answer is because it wasn't sufficient. And at the time, because of the motion to amend being pending, while there is a motion to reconsider the partial summary judgment, you cannot file an appeal in the U.S. You have to wait for the motion to amend. Then that order becomes, partial summary judgment becomes a final partial summary judgment. And then you file your appeal. And that's exactly what happened here. And just like Nick Marsh said, while there's an appeal pending, it's not final, unless a court determines something else, right? The relevant court. Well, what did this court decide? This court decided, according to USC 28, that they may register the judgment in any judicial district jurisdiction where they determine one or more defendants may have assets. This is the jurisdiction of the United States. 28 USC is not jurisdiction outside of the United States. And the purpose of this order is that Camshaft is located in Florida. And as a consequence of him being the fund being located in Florida, they could not take the partial summary judgment and passport it into another federal court, as Nick Marsh says, in Florida. They need this order to do that. And when they do that, they then could file their writs, which are also the evidence provided by the claimant. And so that's perfect. The claimant's following U.S. law. I love it. They get the partial summary judgment. They're waiting for the motion to amend. While that's pending, they can still file for another federal court. And this allows them to go to another federal court. But it does not allow them to go outside the United States. It's all inside the United States. No different than in France going to a different arrondissement or in Australia going to a different state. It's okay. It's perfectly normal. And that makes sure there is remedy available for the defendants who may or may not have assets in a judicial district jurisdiction. The DIFC is not a judicial district jurisdiction. Definitionally, it is not. So relying on the May 7th order gets plaintiffs nowhere to come to the DIFC. And as a consequence, if I strike out that order and I use the fact that, and let's go now to, I need the page, forgive me. One moment, I'm just going to pull the bundle number because I have the index number for the witness, forgive me. And so if we look at so we've got Nick Marsh agreeing it goes to federal courts, and we've got Peter Van Tol in his first witness statement at page 8428. We can please go to that. Then in 8428, paragraph 32.
32.
Oh, forgive me, I'm on, it's not the right page, I'm sorry. Yeah, 8428, I'm sorry, I said 824, excuse me, 8428. That's not the right paragraph.
8424.
Yeah, 84. It's paragraph 32, which is located on page 8424. The U.S. disclosure shows that Ravindran has minimal assets. He does not know where the alpha funds are. And he doesn't fit the test for the district that you can register against Ravindran in another court, another defendant. The only other defendant is Camshaft. And then you go to page 6606, please, of the bundle. Where it refers to the partial summary judgment before this May 7th order, right? Because they need the 7th order to take it out of Delaware. They need that order to take it to another federal district court.
So what am I looking at? It's 6606, did you say?
6606, we're looking at paragraphs 22 to 24.
Of what?
Oh, I'm sorry, that's Franinsky's
Right.
first witness statement referred to as DHH2, which is in index 65.
Okay.
And does it say that? And yeah. Thank you. And then in
So which paragraph am I looking at that on back?
We're in 22. We're in paragraph 22, Your Honor.
Okay.
And what they're relying on is the boilerplate text of it's immediately effective and upon its entry inside Delaware. Okay. And they're saying, well, that allows me to take it somewhere else. And then Nick March says, no, you can passport it, but you need this May 7th order, and then you passport it into other federal district courts. And claimant is saying, no, not only federal district courts, but you can do it, you can passport it effectively also to the DIFC because it is, quote, functionally equivalent. And it's not functionally equivalent, that's the whole point. So then when we continue with Hraninsky, even Hraninsky in paragraph 23 says, well, even if it's not enforceable, it's generally enforceable 14 days after the entry. Well, they didn't bother telling you that. And then it talks about, he says that you have to, paragraph 24, to register the order through the May 7th order. So paragraph 24 goes back to that May 7th order again. And the U.S. court, it's unhelpful for the plaintiffs because we'll go back to March in a second. It says the court as recently as the 15th of July reiterates that the order remains in effect and is not stayed. That's absolutely true because the motion to appeal is before the district court and there's a motion to stay pending before the district court. And at that time, there was a motion to stay pending before Judge Shannon in the first court, the bankruptcy court. And so the statement is not yet granted is absolutely true, but it's incomplete because it doesn't say, oh, by the way, it's pending. They're all pending. And if I go back, please, to page 889 to Hraninsky, we're going to continue on Hraninsky 889. No, I'm sorry, March 889. We're going to look at 138, which carries on to 890. Hraninsky, recognizing the relevance of obtaining the 7th of May, and this is where this term functionally equivalent comes from, Your Honor. So this is really important. Their whole argument is based on this functionally equivalent definition, which they try to tie to Article 31.4 of the courts. If you continue reading, it's got to be registered, and it says, this is great. I love it. I love Marsh for this. The last sentence on 138 says, I'm sorry, on 889 says, I also understand while the U.S. court does not have remedy exactly like a worldwide injunction, so there's no equivalent to a freezer, so the Moreva doesn't happen. In other words, there's no remedy exactly like the DIFC remedy, right? He admits it doesn't exist. He says functionally equivalent. It is great. He says other courts, such as this in the U.S., nowhere else on earth, as the U.S., such as the state and federal of New York, Florida, Camshaft, Delaware Chancery Court, in relation to these proceedings, do have this type of injunction in aid of claims for equitable relief brought in other jurisdictions. In this case, it means U.S. jurisdictions, but that's fine. And he says, for example, when I want to passport it to another U.S. district court, this is what happens. I'm more than happy to spend my time with Nick Marsh on his hearsay being unqualified in U.S. law to talk about passporting, but the fact is, Hraninsky and Peter Van Tol do not dispute that it is not functionally equivalent, the 7th of May order, to a DIFC order. It is not functionally equivalent. And as a consequence, applying 31.4 as to jurisdiction, which was one of the most relevant questions you asked me at the outset of this apparently monologue, apologize, I believe we've answered that it is very, very clear that a requirement must be for there to be a final judgment. There is no final judgment. It's a fact. There is no final judgment. Marsh makes clear that in order for there to be final, a functionally equivalent, in order for final to be functionally equivalent, so they're not saying it's final, they're saying it's a functionally equivalent final, it's when an appeal is resolved. And the other two tests, the second test doesn't apply at all, nobody argues it does. They rely on the third test because they fail on the first test. Now, it's an or, right? It's may be available once any appeal has been removed, the time to appeal expires, or a finding. Now, there's no finding of good cause in May 7th. There's no finding of good cause in May 7th. There's no finding of good cause in the partial summary judgment. There is an appeal of the partial summary judgment, and consequently, 31-4 is not met by claimant. That effectively kills their argument on 31-4. They have no evidence before the court to contest what I just said. I can appreciate my good learned friend's going to make some submissions, but I'm using his own evidence. So unless he can add some evidence that I'm not aware of, I'm happy to rely on his own skeleton. Now, it is not a defense on the merits. As I've explained to Your Honor, the difference between the jurisdiction to issue the order requires there to be a final judgment. There is no final judgment. A continuation requires, possibly in aid of foreign proceedings would be different. They have to bring a Part 7. They haven't. They're still, to this day, according to the test of Nick Marsh in paragraph 138, it cannot be passported. So in order to passport the partial summary judgment out of the United States into the DIFC as a final judgment, it cannot be done with an appeal. Now, we'll end up talking about that, but that's clear from their own evidence. When I go to paragraph 103, right, it's not true in the skeleton where he says the order does, in fact, contain a functional equivalent. It does not. I've just shown you that you cannot take the text enforceable in all jurisdictions without the May 7th order, which does not allow it in all jurisdictions. It clarifies all U.S. jurisdictions. And the U.S. order is final, binding, and enforceable in the U.S. False, again, for what I've shown you under 138. It might be final and enforceable in the sense that it exists, but it's under appeal. And as a consequence, it does not satisfy the DIFC test. So there's a difference between the DIFC test and the U.S. test. Now, turning to, I've disposed of the argument in 106. I've disposed of the argument in 107. I've disposed of the argument in paragraph 109. The first sentence, whether it's boilerplate or not, that's irrelevant. Okay, it's boilerplate, whatever. Quite relevant for Your Honor on the law issue that we spoke about at the very, very beginning of this, what law prevails. In this way, the U.S. court retains its own jurisdiction. So competence still applies on this. They determine their jurisdiction. They've accepted the jurisdiction. It's not in dispute. The U.S. court has this jurisdiction. This court cannot determine that it is final because the U.S. court has to determine that. And this court either can say, I don't have evidence it's final, or I do have evidence it's final, but it must be treated as a matter of fact. And as a consequence of the test in 138, it does not meet the test laid out in paragraph 100 of the skeleton, that it has to be of an equivalent standard of finality. It does not meet the test of an equivalent standard of finality. When I turn to skeleton 111 to 113, it's interesting that they accept that only this defense, only this claim is valid. They don't understand that, no, the other ones are not merits. The other ones are not merits arguments at all. The other arguments, they are in fact jurisdiction arguments. That does the court have the power, as we've discussed? And they say whether or not this is the proper forum. They are saying that it's an invitation to the DIC court not to exercise its jurisdiction. That's not true. The court does not have discretion to exercise its jurisdiction if there's no final award. It sets the cart before the horse. I'm sorry, you're on mute, Your Honor.
Thank you, Mr. McNutt. I don't think that's what they're saying. I think what they're saying there is they're referring generally to the principle or doctrine of forum non convenience. And they're saying that that doctrine applies when a court has jurisdiction, and the doctrine is applied by the court deciding not to exercise its jurisdiction. So it's a separate argument there.
And I'm trying to understand the relevance of that argument if there's no final judgment.
Well, no, but as I understood it, I think what they're addressing is an alternative argument by the defendants, where I think the defendants are saying first the court doesn't have jurisdiction, but then I think the, as it were, second argument or a further argument the defendants put forward is if the court does have jurisdiction, it should not exercise it because of the doctrine of forum non convenience. I think that's what they're saying.
Yeah, no, that's correct. And that's my understanding as well. And right. I'm saying, though, that that subsidiary, I view that as a subsidiary, not parallel. And I think that's the only difference. Maybe, again, that's my French side. We present not parallel. We have to present primary and subsidiary or consequential. Okay. To me, that's a consequential, not an alternative. And forgive me for that presentation in that respect. So the last thing they say is quite funny is the jurisdictional challenge has not challenged the claim for enforcement under UNCITRAL. Well, there's no reason to challenge under UNCITRAL if you apply the test in paragraph 100, which they claim is the test. They don't claim the test is UNCITRAL. They claim the test is a U.S. law test, that the functional equivalent under the U.S. is this. And so they don't explain why UNCITRAL would be a proper test in the circumstances that in paragraph 100, the Article 31.4 requirement says that they have to have executory formula under 31.4 or satisfy a standard of finality under the foreign law from which it originates, being the U.S. It doesn't say or UNCITRAL. It's only two. So I don't believe it's worth the court's time to even hear that argument, because they can't add that argument since the law itself doesn't give that argument. There's no standard to add UNCITRAL. It's either the law itself provides it, or it satisfies a finality under the foreign law from which it originates. And I would argue that the U.S. judgments comply with UNCITRAL anyway. So where is the special nature of this UNCITRAL defense against the jurisdictional challenge? I would propose that I stop there. I would respectfully ask, given something I'm not going to discuss publicly, if we could take a 2-minute break and allow my good learned friend to gather his notes. If I could take a personal break for a moment. Sure.
So just to be clear, Mr. McNutt, you've addressed both the jurisdiction application and the set-aside application.
I have not addressed the set-aside because the nature of the proprietary injunction. You're talking about the jurisdiction of the proprietary injunction.
I see.
Yeah, I see.
Yes.
I did not address jurisdiction on proprietary injunction because that issue relates to whether or not there is a preliminary injunction in the United States, which is different than is there a partial summary judgment? And here, claimants have a slightly different problem. They have a two-headed monster here. On one hand, if the preliminary injunction in the United States falls away with a partial summary judgment, then it would be reasonable they would seek a precautionary injunction in the DIFC, if possible. That makes sense. But if they argue the opposite, that the preliminary injunction remains valid in the United States, then in the DIFC, it is duplicitous because they already have the relief of the court. So we need to just get to the bottom of that out, right? We'll do that in the set-aside application.
All right. All right. Now, to be clear, you suggested, do you want the 2-minute break, or are you just thinking that Mr. Montague Smith might want it?
I think we both might need it, but I assure you I definitely need it. And there might be others as well. I apologize.
All right. Well, perhaps we'd better make it a 5-minute break. I think 2 minutes.
Thank you.
So we'll make it, we'll resume at what will be 12:39.
Thanks.
Yes, Mr. Right. All right. Well, I think we're ready for Mr. Montague Smith.
Very good. Thank you, Your Honour. All right. Can I just remind Your Honour of the scope of the application that's being made? Because I think there's a bit of confusion there. On this part, the jurisdiction application is aimed at the claim. It is not aimed at the injunctions. So I'll just show you that. If you go to page 344, you'll see the... Sorry. I might have got that wrong. 354, perhaps. Yeah, 354, please.
Case. This is the case, statement of case.
Correct, yes. And so you'll see paragraph 2. First defendant's application challenges the jurisdiction of the DIFC courts over the claim brought by Byju's Alpha for the following relief. Now, there is also what is described as a jurisdiction objection to the proprietary injunction. And if you go to 462, and then go, that's the set aside statement of case.
Oh, I see. Yes.
And then if you go down, please, to page 464, you'll see under the heading absence of jurisdiction. But what happens next, and this is the point I made at the last hearing, is that paragraph 10 then launches into the merits of the application. So it talks about serious issue to be tried. Now, in my learned friend's recent skeleton, he doesn't seek to characterize those submissions as a jurisdiction objection to the proprietary injunction. And that must be right, because they're obviously not. So the question is whether or not the DIFC, on this application, is whether the DIFC court has jurisdiction over the claim. And you will recall that the claim is essentially in two parts. One is to enforce the US summary judgment, and one is to enforce the precautionary injunction. So you can see that from the particulars. I won't take Your Honour through them in too much detail if that's all right, but they start at page 6.
Okay.
And it's probably easiest to pick it up from the prayer, which you'll find at page 16 of the bundle. And you see that Your Honour will see there in the prayer. As against the defendants, all of them, recognition and enforcement of the US summary judgment and the US summary judgment order, then the judgment in the amounts that were ordered in those proceedings, and then you will see below that recognition and enforcement of the US preliminary injunction. and an injunction in the form set out in paragraph 67, and that's the preliminary injunction or precautionary injunction, however you want to call it. So there's two parts to the claim, and that's really what my friend needs to deal with. What's the jurisdiction to recognise and enforce the Delaware judgment, the summary judgment order, the SJ order, however you want to call it? What's the jurisdiction to recognise and enforce the US preliminary injunction? And that is why, just pausing there, my own friend raises the issue of the Nadil case and takes you to the decision of the Deputy Chief Justice. But that's not in these documents, his application. And there must be a reason for that. It's because those are dealing with the powers to grant freezing orders in support of foreign proceedings and the court's jurisdiction to do that. It's not dealing with the court's jurisdiction over claims to recognise and enforce foreign judgments. Now, it talks about that incidentally, but there was no, for example, that there's no allegation that you will find in their statement of case that because there are no assets in the DIFC, there's no jurisdiction over the claim to enforce the judgment, and that's sort of historically been the position. Now I'll pick that argument up as we go because it's been raised orally, and your Honour may be concerned about it, and I'll deal with it. But just to keep this in focus a little bit, if we can, really it's quite simple. We say, and essentially what we say is, if your Honour has the claimant's authorities bundle, it would have come in separately. And if I can just take you to the law itself, and that's probably the best way to do it.
This is the 2,000-page one?
I'm afraid so, yes.
Yeah. That's just that I have two, so
I see. All right. Yes,
one.
Good. Yeah, sorry, I was detecting perhaps a degree of criticism about the number of authorities.
Not at all. Not at all.
So what I was going to show you was just part of the new court law, if I may. And we find that at page 100, I'll take you straight to Article 31, which is page 120 of the bundle.
Yes.
And so essentially what we say is that the claim to enforce those things is simply and straightforwardly arises under Article 31(4), and that provides for the enforcement of judgments and judicial decisions affixed with the executory formula issued by local or foreign courts, including the Dubai courts. That therefore deals with the enforcement of the USS summary judgment order, but also it permits, as well as, interim and precautionary orders and decisions issued by local or foreign courts. So Your Honour raised the question during the course of submissions, do we accept that the order has to be final in order to be capable of recognition and enforcement? Answer, no. Now, we do say it is final, but we rather endorse Your Honour's view, which is that all of that comes later. The short question is simply, does the court have jurisdiction to recognise and enforce, number one, a judgment, the US summary, a judgment from the Delaware courts, and number two, an interim judgment from the Delaware courts? And we say the answer to that is yes. And that's really the sort of start and the end of it in our submission. Now, obviously, I'm not going to put my pen down there and say that's enough, but I'll deal with the points that are raised against me. But all of those points have to overcome that threshold question, which is it's got anything to do with jurisdiction at all? Now, in addition to that, we made submissions about why, even if all of that was wrong, you would have jurisdiction. Sorry.
Can I stop you, Mr. Montague-Smith? I understand you're going to go on and deal with the arguments, but if I was with you on the view that it doesn't go to jurisdiction, strictly, is that the end of it?
Well, you've still got to deal with the foreign non-convenience point.
Oh, so yes, sorry. Yes.
But we would say, broadly speaking, that is the end of it. Now, you are going to, I'm afraid, have to hear my submissions on whether the order is final,
I understand,
and whether or not whether or not the precautionary injunction remains in place. because those are put against me in various different other ways. And so I was going to propose to deal with those in these submissions just to get them out of the way. And if that's acceptable to you, I can move things around. But just pausing there though, I mean, when we approached you on the ex parte, we obviously made a number of different arguments for why the court had jurisdiction to make the order. And in part, that was ancillary to the claim that we made against Mr. Ravindram. And therefore, the jurisdiction complaint that is made about the claim is relevant to that extent. But of course, we also made other arguments, ancillary arguments, which haven't really been dealt with, about why we said there was jurisdiction, even if that claim can't survive in one form or another.
But it's jurisdiction to make the freezing order and the proprietary injunction. Correct.
And the other parts of the law that are relevant are, firstly, Article 15.4 of this law, which appears at page 112. And that's the one that implements what we described as the Carmen jurisdiction from the notorious foot-in-mouth Australian submission. But Article 15.4.
I only raised it because I found it amusing, Mr. Montague-Smith.
Your Honour appears to continue to find it amusing, and that's we can all laugh at ourselves. But one day I'll find it amusing too, I suspect. Article 15.4. Applications, claims, or current or future arbitral proceedings brought out. Sorry, I should start at the beginning. The DIFC courts have jurisdiction to hear and determine applications for interim or precautionary measures related to the following, and then 4 includes claims or current future arbitration proceedings brought outside the DIFC. So even if my friend was correct about his jurisdiction dispute about the claim, that leaves him with a problem, which is that he hasn't addressed my arguments under 15.4, and he hasn't made an application based on that. Now, this is the area where Nadil would be relevant, but
I'm sorry to stop you. So, if he's right on that, that goes. His argument goes to the claim, but not to the freezing order or proprietary injunction.
Correct. Yes.
Yeah.
That's exactly right. Because so the way we put it was really in 4 different ways. The way that we advance the injunction. I can show you this in the skeleton, but I'll just summarize it. So firstly was a claim to enforce the US preliminary injunction. So that's the first one. And that is attacked by his jurisdiction objection against the claim. Secondly, was in support of the enforcement of the US declaration and for consequential relief on the basis of that. So again, that is squarely within the scope of his jurisdiction application that he advances. But there were 2 other ways. One was under Article 15.4, as I described, simply in support of the US proceedings. And the other was in support of the model law enforcement of the proprietary injunction. And those are rather waved away, but they are real, and there is no application for a jurisdiction dispute in relation to those, and any such application would have had to be made within the appropriate time frame. But I'll deal with all of it, but there's a threshold question there. There was some suggestion while we're in the law, there was some suggestion in the written argument, the skeleton argument, that there's relevance in Article 32A1 of the new law, and that appears at page 121. I'll just clear that away. My friend skeleton argument refers to this provision as somehow being relevant. And if you look at Article 32, you can see why, because that's enforcement by the Dubai courts. So that's got nothing to do with anything that you have to decide today. So where you see that referred to in the written documents, it's irrelevant. Now, the jurisdiction challenge that we face has evolved slightly, and there are different ways that it's being put. But ultimately, we detected 5 points made against jurisdiction. And there have been, so that I'll list them out and then I'll tell you what's new. First argument is that the order, the summary judgment order, is not affixed with the executory formula. And second, it's said that there are challenges to the summary judgment order, and the punchline seems to be that it's not therefore final. Third is this argument that the US court retained jurisdiction to itself. Fourth is forum non-conveniens. And then the fifth argument that's raised is whether or not Mr. Ravindran submitted to the United States courts. There is then this new point in the skeleton argument. So the sixth point that is now raised, this is the reliance on the Nadir decision, the Deputy Chief Justice's decision in the case we discussed at the ex parte, and seventh appears to be a point, at least in the skeleton argument, which my learned friend mentioned at the end but didn't develop, but it seems to be borrowed from the other application, is this point that the preliminary injunction has ceased to exist. So that's the collection of the ways in which we see that the application is put against me. So the first, I'll just run through those if I may, and I appreciate it's getting towards the time when you said you'd like to stop. So I can.
Well, you pick a convenient time.
Well, I'm about to embark on an argument which is really this question about the executory formula and finality,
So
and that's likely to. Might be now.
Okay. How long should we adjourn for? I know you're all in. Half an hour, 45 minutes, an hour?
I'm in your hands. From my perspective, it is 10 a.m. So yeah. I can go and have breakfast. I don't need a lunch break, but other people may, and the court staff may. So I'm yeah. very much in your hands. Mr.
McNutt?
I'm at your discretion. I'm not afraid of food, but I'm also not afraid to go on, and we can continue now for another 30 minutes. I mean, it's up to you, Your Honor.
Well, I think I might give the court staff a little longer. We might make it 45 as a sort of compromise. So yeah. we will resume at 1:45 Dubai time.
Apologies. Thank you.
All right. Thank you. Mr. Montague-Smith.
Thank you. All right. So I was going to move on and then just deal with each of these arguments.
Yes.
As we saw them arising. Yeah. Okay. So the first point is there's no executory formula. That is, we say, firstly, threshold point. That's not an argument about jurisdiction. But leaving that aside, we'll come on and look at it. The test, if we look at it, if you've still got the authorities bundle open, you'll see the test is in 31.4. And so we were looking at page 120 of that bundle. Article 31.4 deals with the enforcement of judgments and judicial decisions affixed with the executory formula. Now, there's a question about who has to apply that executory formula, whether or not it is the local or foreign courts, because it's followed by the words issued by the local or foreign courts, but that could equally apply to the judgment. So it's the enforcement of judgments and judicial decisions affixed with the executory formula issued by local or foreign courts. Now, happily, there doesn't seem to be too much of an argument between the parties as to whether the effect of this strictly is that the foreign court just must write down words akin to an executory formula on the document, because I think it was accepted, and Mr. McNutt referred to this, it's certainly accepted in the written case, that it's a question of substance, not form, if I can put it like that. So the way that I'll show you what he says about it, it's at page 356 and paragraph 10. And this is in his jurisdiction statement of case, paragraph 10, and it's the second sentence. The function of this formula is to certify that the judgment is final, binding, and enforceable in its jurisdiction of origin, and then goes on to say, therefore, for the DIFC courts to assume jurisdiction under Article 31(4) of the DIFC courts law, the judgment or order sought to be enforced, and then he gives two options, must be demonstrably final and executory, and must either bear an executory formula as understood under Article 31(4) of the DIFC courts law, or satisfy an equivalent standard of finality under the foreign law from which it originates. So the parties appear to be ad idem on the question of whether or not there is an obligation on the part of to show that the foreign court has actually applied an executory formula. And I draw and what we say is that must be right, because there are going to be courts in jurisdictions who will not have anything like an executory formula. And the way we put it, I think, is that if this isn't to be effectively a legislative sidewind, which excludes the enforcement of a whole swathe of foreign judgments where that might be the position, then one has to give a purposive interpretation to this. So whether the purposive interpretation results in the conclusion that it is the DIFC court that can affix the executory formula, or where the reference to the quotes executory formula are really to be understood as meaning that the court has to be satisfied of the relevant matters. It doesn't much matter. What we would urge against you, what we would urge your Honour not to find, is that there is some strict formal requirement which may or may not be available in certain foreign jurisdictions, but which somehow is a requirement if those judgments are to be enforced in this court. Now, the issue doesn't arise in this case, so I say that really for posterity, because we do here have something that is, as we put it, functionally equivalent to the executory formula. But I just remind your Honour again of the case that we are trying to meet, and that is paragraph 10 of my learned friend's statement of case, that it's about final, binding and enforceable in the jurisdiction of origin. So you've got quite a lot of argument about the need to get orders permitting passporting out to other US federal jurisdictions, but none of that is relevant to the question of whether or not it is enforceable within the jurisdiction of origin. You also had quite a lot of submission about functional equivalence. I think I heard that expression more times than I have in the past few years, in a very short period. Can I just show you what my case actually is in relation to functional equivalence? And what I said is that paragraph 103 of our skeleton argument, and I'll come on to show you the actual paragraph that we rely on, but what we say is there's something in the judgment which is, and this is the middle of the end of the first line of paragraph 103, there is a paragraph in the summary judgment order that is functionally equivalent to the executory formula. So we're not suggesting that there's something the issue, we're not raising the issue of functional equivalence of one order to another order. We're talking about just that statement in the summary judgment order and saying it's effectively an executory formula. And I'll show you that in a moment.
And if you're taking a purpose of interpretation, the judgment itself must display this finality.
Yes, that's another way of understanding it. So either the judgment is effectively, as a matter of properly understood under the system of law from which it originates, it is expressing itself to be executory, to summarize. The other way would be to say, well, if it does need to have some sort of formula applied to it, then that formula could be applied by the DIFC court. But there are a number of different ways to do it. But ultimately, as I say, what we urge you not to do is
the difficulty with that latter suggestion is that requires the DIFC court to conduct some sort of examination about whether it's final or not.
Well, the court probably has to do that if it's contested on the merits anyway. And so, for example, I'll take you to Barclays Bank because that's one of the cases. But ultimately, one of the points that was made there is it's not final because there's an appeal. It's not final because there's an application to set aside. And so the court did have to look at that under the common law test, at least.
Yeah.
So I think most common law courts, when they're enforcing a foreign judgment at common law, would ask the question: is it final and conclusive? They wouldn't actually be interested in whether it's enforceable in the local court. But that may or may not be part of the new test. That remains for debate. But there's no difficulty in certainly the DIFC court taking a view of whether the common law test for finality, for example, has been satisfied. And the common law test is, does it have res judicata effect? That's really the common law test. So a stay of I'll get there, but a stay of execution in the issuing court doesn't suddenly render the judgment no longer final or enforceable. What it can mean is that the enforcing court may be persuaded to also stay execution against the judgment, but that comes at a later stage. And even that is not a foregone conclusion, and that's one of the things that happened in Barclays Bank. So but just dealing with this idea that somehow there was, I think my learned friend said, well, there's just no answer to his arguments in relation to this. But he took you, for example, to page 889 of the bundle, which is in Mr. Marsh's first affidavit. And he showed you paragraph 138 and made submissions as if that was somehow relevant to the issue that you have to decide on this point, and it's not. And I think the reason why he said it was relevant was because 4 lines down, Mr. Marsh uses the phrase functionally equivalent. But you can see from the next line that he's not talking about what I was talking about in my skeleton, because he's talking about functionally equivalent relief. The point of this paragraph was to make the point that it may be arguable but difficult to obtain a freezing order in Delaware. And that's perhaps one of the issues that you might consider when deciding whether or not it's expedient to grant the relief in the DIFC. And so that's why that was brought to your attention. But this isn't some sort of concession, and it's very difficult really to understand what the relevance was being said to be about these passages, other than just latching onto that phrase, functional equivalence. We say it's just completely irrelevant to the issue. So in any event, whatever the requirement is for an executable, an executory formula, we have one, we say, in this case, in terms, because if you go to page 2590, you can see the summary judgment order itself, paragraph 7 of it. And it says the terms and conditions of this judgment order shall be immediately effective and enforceable upon its entry, notwithstanding any provision of the bankruptcy rules or the local rules to the contrary, and that a debtor may, in its discretion, without further delay, take any action and perform any act authorised under this judgment order. Now, I'll explain in a moment. Well, we'll come on to it now. I'm dealing here with, firstly, is there an executory formula, but also the subsidiary argument, which is it actually final, conclusive, and enforceable? So really, we say that is the executory formula. That also shows that it satisfies the test that it's final and enforceable, final, binding, and executory. We have evidence on this issue from Mr. Herinsky, which is at 6606, and you were shown some of it, but I'll just show you what I say about it briefly. 6606, and it's paragraph 23, and he explains, he recites at paragraph 22 the paragraph I've just shown you of the summary judgment order, and then he says, paragraph 22, it is therefore plainly and on its own terms final, binding, and enforceable, and can be enforced in other courts. And then paragraph 23, even if the US SJ order had been silent as to when it became enforceable, judgments issued by US bankruptcy courts, of which the US court is one, are generally enforceable 14 days after their entry. And he gives there, you'll see footnote 2, which refers to a particular rule, 7062, and he recites that rule, which talks about a specific rule in the bankruptcy courts, which says Rule 62 applies in adversary proceedings, except that proceedings to enforce a judgment are stayed for 14 days after its entry. And then we've got both Rule 62 and Rule 7062, but Rule 62 talks about, he summarizes it under Rule 62, the automatic stay of enforcement would have been for 30 days after entry of a judgment. So there's a variety of different automatic stays on execution which might arise, one for 30 days, one for 14 days, the 14-day one being specific to the bankruptcy set of rules. And then the effect of the order is to say, actually, none of that applies. So it's now immediately enforceable. I can show you the rules if you like, or I can give you the note to where they are in the bundle, but they're just so you've got them in case you want them.
Yes, just give me the place.
Certainly. That's Rule 7062 is at page 4541.
Sorry, what? Say it again.
4541.
Thank you.
And then Rule 62, which is the general one, that is at page 7941.
Thank you.
And there are other express orders in the United States which evidentially support the conclusion that this is a final and binding and enforceable judgment. So you've been shown one of them, which is at 3068. And that says, paragraph 2, plaintiffs may register the judgment in any judicial district jurisdiction where they determine that one or more defendants have or may have assets. This is the sort of passporting process that was undertaken within intra-United States. Now, I think that what's being suggested is that somehow this indicates that there would otherwise not be permission to execute outside Delaware. This is a particular process for enforcement in other United States. No one has suggested that there is some process in Delaware which requires an application to the court for permission to enforce out. And in fact, when giving evidence about this, Mr. Van Tol expressly disclaims any statements about whether or not this judgment would be enforceable outside the United States. I'll show you that. So page 8422. Right. 8422. and just starting at paragraph 24, and this is dealing with a slightly different issue, which I will also come on to, but he makes a statement in general terms. This is Mr. Van Tol, who acts for Mr. Ravindran in the United States. He says, I agree with Mr. Horitsky that the bankruptcy court's retention of jurisdiction is standard language and does not speak to the finality issues. So I'll come back to that in a moment. And then he says, paragraph 25 over the page, however, in contrast to Mr. Horitsky, I offer no view on whether retention of jurisdiction affects the ability of a foreign court to enforce the US SJ order. That is a matter for foreign courts to decide. And in this case, I am not qualified to speak to matters of DIFC law. So essentially what he's saying is, when you get outside the bounds of the US, it's not for me to say what the foreign courts can and cannot do with this order.
Yeah.
The other point, there are a number of other short points I'd like to make about this question of final and effective, or final and conclusive, final and enforceable. First, if I can show you page 7507. And we are here in a transcript of, and I'm sorry, I've forgotten which proceedings this is, but this is the US court's decision. Someone will tell me. And if we look at page 49, paragraph, lines 17 to 18, the judge says this. He's talking, we'll start at paragraph line 15. I am concerned that the ability of the judgment holders to proceed and execute and recover to the extent possible upon a judgment entered by this court that remains in effect and is not stayed would be impaired in the absence of the relief that has been requested. And so in considering a motion, the US judge is saying this is a judgment which remains in effect, and that is one of the reasons why he was concerned about the relief. Sorry, and that is a hearing in relation to the motion to amend the protective order. That's the order that prevented disclosure of certain of the evidence. And the other point to make is that there are a number of execution orders that have already been issued in the United States. So these are summarized at page 6606, paragraph 25. And it's paragraph 25. Mr. Horitsky says, enforcement of the US SJ order has already commenced in the US against assets of one of the other defendants to the US SJ order camshaft. And you've got copies of those execution orders in the bundle at 7435 to 7440. So this summary judgment order is actually being executed by writ, fieri facias, in against one of the other defendants, which would make the idea that it is not somehow final, conclusive, and enforceable very odd indeed, because you wouldn't be able to execute if it was not. So what seems to be being said is that there are effectively two things that make or made this order not final. One was the reconsideration motion that has subsequently been refused, and an appeal, which is now pending. Mr. Horitsky explains in some detail why neither of those applications could affect the finality of the order. And I'll just show you briefly what he says about that, if I may. First is at page 6609. Paragraph 34. He talks about the motion to stay. Sorry, that's the other aspect of it. And then says, in brief, the motion seeks a stay of the US SJ order on grounds, including the US SJ order violated due process and so forth, and deals with that, and says, and he goes on to say that in the meantime, that the parties must comply with the order. And he cites authority to that effect, which you will find at page 7730. And then he goes on to cite authority to the effect that a stay would be exceptional or extraordinary. As to an appeal, that doesn't make the order ineffective either. That's dealt with at page of the bundle 6611. And it's paragraph 42 there. Notes that this isn't actually part of the jurisdiction objection, but goes on to say that there's an appeal, there's a reconsideration, there's a refusal of the reconsideration motion, there's an appeal against that too, and then says, if the motion to stay is denied, which is likely, the pendency of the appeal will not affect the enforceability of the US SJ order. And he gives authority for that, and you see that in the footnote. And he refers to their Snyder case. And I'll give you the underlying references to the page numbers, but I won't, unless you'd like me to, I won't take you to the full detail of it. But the citation is, the pendency of an appeal does not affect the potential for res judicata flowing from an otherwise valid judgment. That's Snyder, and you'll find that in the bundle at 7961. And then he refers to, after that, you'll see 3 lines down, the restatement second of judgments, 1982, section 13. And he explains what that says. A judgment otherwise final remains so despite the taking of an appeal, unless what it is called an appeal actually consists of a trial de novo. That's not this case. Finality is not affected by the fact that the taking of the appeal operates automatically as a stay, supersedious of the judgment appealed from that prevents its execution or enforcement, or by the fact that the appellant has actually obtained a stay or supersedious pending appeal. The fact that there is also an appeal also indicates that the USSJ order is final, and goes on to cite that. And the reference to those 2 authorities are in the bundle at 8043 and 8160. And all of that is consistent with prior DIFC authority about how DIFC authority looks at foreign American judgments, albeit in the one I'm going to show you, the argument was about a judgment of the Southern District of New York. But I can show you quite briefly, it's in the authorities bundle. That's the claimants, the longer one, at page 346. And if you have the time, you can do it now. You can make the note. I can show you the conclusion, but it's 49 to 51 of these. And the issues there were that there was an appeal, but there was also a process by which the first instance court itself could set aside its own judgment. So a bit like a default judgment situation in the DIFC court. And the question was, is that nevertheless final? Because it was being argued that because the first instance court could overturn it, it wasn't final. And at 51, Justice Sir Richard Field, this is on page 347, he says, just as the pendency of an appeal against a foreign judgment does not render that judgment otherwise than final and conclusive, so too, in my view, is the New York judgment's final and conclusive character not affected by the pending motions to have it vacated. and goes on to make the point that a judgment in default can be final and conclusive, even though it might be set aside on application. So the position of DIFC law is that an appeal, a motion of reconsideration, something like that, doesn't affect the finality. Obviously, if it's successful, then it will affect whether there's a judgment at all and what the terms are of that judgment. But unless and until you get there, it makes not a jot of difference at the execution or the enforcement stage. So Mr. Rene pointed out in his evidence that this argument that's being run, it's not final, it's not conclusive, was impossible to square with paragraph 7 of the US summary judgment order, which is the one that I showed you, which says it is final, it is enforceable. And we have a response from that from Mr. Van Tol. But importantly, Mr. Van Tol does not say anymore, at least, or never really did say, that it's not final and conclusive. What he says is there might have been practical difficulty in enforcing this order pending the reconsideration motion. So I'll show you precisely what he says there.
Does he explain what he means by that?
Not really, no, it's just assertion. Let me show you, if I may. It's page 8420. So he's dealing with this point I've just mentioned, which is that Mr. Rene points out, paragraph 7 of the order says it's immediately enforceable. And then he says this, paragraph 13, halfway down, that language, however, predated the reconsideration motion filed on the 25th of March 2025, and it does not answer the question of whether, as a practical matter, claimant could have enforced the US SJ order in another jurisdiction. So then what he says is paragraph 14, and this is the best explanation we have. While the reconsideration motion was pending, which was the case as of 21 May 2025, there was a possibility that the bankruptcy court could revise the damages substantially and alter the obligations of the parties. Thus, if claimant had taken the US SJ order to another jurisdiction for enforcement prior to the determination of the reconsideration motion, it is highly likely that the court in the other jurisdiction would have refused enforcement given the possibility of a material amendment. So essentially what he's saying is the other jurisdiction, whatever that might mean, might have said, well, there's a reconsideration motion going on. It's final and conclusive, but I'm going to wait and see what happens in that before I do anything. And that's perfectly possible. And you know, that is what the reconsideration motion was one of the things that we told you about on the ex parte hearing. But obviously the relief that we were seeking was temporary and interim relief. And so the position was that the fact that there was this reconsideration motion didn't remove the fact that there was a good arguable case as and when we were discussing it. But Mr. Van Tol then goes on to say, if you go down the page to paragraph 17, so over the page to paragraph 17, he says, I stand by my earlier statement in the June 16, 2025 letter that the US SJ order was not enforceable as a practical matter due to the reconsideration motion as of May 21, 2025. But actually, the letter that he's referring to says no such thing. It doesn't say that at all. The letter is at 365. So this is the letter of June 16th, which was submitted with the application. And it's from Mr. Van Tol. And he says, I've been requested, paragraph 1, I've been requested to provide information concerning the Delaware partial summary judgment. And then he goes through it. He gives quite a lot of background. And then if you go forward to page 368, I'll show you what he does say about the SJ, the summary judgment order. He says, firstly, paragraph 16, the Delaware partial summary judgment is defective in multiple respects. And he says, third line down of paragraph 16, there's a motion to amend the partial Delaware summary judgment. And then he explains it. In paragraph 18, he says the amendment motion effectively requested that the bankruptcy court suspend any enforcement of the Delaware partial summary judgment. Well, that's a slightly wishful paraphrasing of what it did. I think he's saying it must have been implicit. He does confirm there's no actual stay application been made at that point. And then over the page, paragraph 22, he makes that even more clear, because he says, in light of recent developments, Byju Ravindran intends to seek a stay of the Delaware partial summary judgment from the bankruptcy order. And then he goes on to deal with the appeal. And then he says, paragraph 25, the consideration of Byju Ravindran's appeal to the district court will continue, even if there is a stay of enforcement of the Delaware partial summary judgment. So, in fact, this letter doesn't say anything at all about whether it's final and conclusive. And there's certainly nothing in there about practical enforceability. That's just a new response that he's come up with in his evidence in reply to Mr. Renetsky's points that were supported by authority. But ultimately, so the conclusion that because there was a stay, because there was an appeal, because there was a reconsideration motion on foot, that somehow affected the finality. That was just a conclusion that was drawn in the submission. So essentially, it's a submission on the effect, the consequence in DIFC law of an appeal of a reconsideration motion. But we've seen that those conclusions are wrong. But ultimately, what does the current position of Mr. Van Tol come to? It's not saying, as a matter of principle, this is an unenforceable order. It's just saying another judge might not enforce it, might wait and see, or might have waited and seen what happened on the reconsideration motion. So it's not actually anything to do with finality. It's not anything to do with enforceability in principle. And so, as it stands, the judgment meets the requirements and always has. But as I say, there's two parts to this. One is the executory formula. One is the finality. As to the first part, I think you have my submissions on where this your Honour's judgment ought to leave DIFC law, if I can put it like that. But there we go. Right. So the third point that is made is then this one about the final paragraph of the summary judgment order, paragraph 8, and I'll show you that. That is at page 2590. And the paragraph that is relied on is the one that states this court, 2590, as paragraph 8, this court retains jurisdiction with respect to all matters arising from or related to the implementation, interpretation, or enforcement of this judgment order. And the suggestion that has been made by Mr. Ravindran is that means that it is not enforceable in this court. And that, we say, is obviously wrong. We make the point that it's boilerplate language. My learned friend says, yes, I agree with that, but so what? Well, the consequence of that is that every Delaware judgment would be unenforceable outside Delaware. But what it means is, and this Mr. Renetsky has explained it, is that the Delaware court does not need to go through the motions of establishing jurisdiction again in order to deal with arguments about the order. Mr. Renetsky,
it's not functus officio in relation to the matter.
Precisely. Yeah, precisely. And so the evidence for that, if you want to see it, it's page 6611 and paragraph 44. And interestingly, as far as we can detect, Mr. Van Tol seems to agree with this, and at least doesn't disagree with it. And you see that, I've already shown you that actually, that's at 8422, paragraph 24 and 25. And you'll remember I showed you the bit where he says, yes, I agree, it's boilerplate and doesn't speak to finality. But he then goes on to say, but I've got nothing to say about what effect that would have on the DIFC court. That's a matter for them. So what we say is clearly the words, the language, just to get it back in front of you, it's 2590.
Yeah.
The language is clearly not directed at foreign courts. They're just, as you say, reserving jurisdiction so they're not functus in relation to the order. And they don't, I mean, if one reads those words, they don't even purport to exclude anyone else's jurisdiction. They don't say no, and no one else has that jurisdiction. They just say we retain it. So there's nothing in that point either. The fourth point was a bit of subject to a bit of confusion in my own friend's submissions, because the point is made, at least in writing, that there's forum non-conveniens, that the DIFC court is forum non-conveniens. That is said at page 359. Section C of this jurisdiction application is forum non-conveniens. It's also said in my learned friend's skeleton at paragraphs 44 to 50. And the short answer to that is forum non-conveniens never arises, never has arisen on a claim for recognition and enforcement of a foreign judgment. And we give you the authority, this point has been run, but we give the authority for that in arbitration. This is the only court that could enforce a judgment in the DIFC. Full stop.
Yeah.
The authority is Banyan Tree, Maiden and Banyan Tree. It's in my authorities bundle at page 225, paragraph 39, where the then Deputy Justice, Chief Justice, Sir David Steele, said that in terms. The DIFC court is the only court which could recognise and enforce a foreign judgment in the DIFC.
Seems obvious.
It does seem obvious, but these are the points we're dealing with. I mean, just to test it this way, Mr. Ravindran's case in his skeleton is that the US courts are the natural and appropriate forum for this claim. So the consequence of that would be, again, you can never enforce a Delaware judgment outside the US. The fifth point that was raised in writing, but has not really been developed today, is that there is a pending jurisdiction challenge in the United States. Mr. Ravindran says he challenged jurisdiction in the United States and that challenge remains outstanding. Again, there's a threshold issue here. That's a merits objection. It would be about whether the US court had jurisdiction. It's not a jurisdiction objection. And the other point I'd make is that it's relevant only to one of the ways that we've actually put the merits of the case. Your Honour may recall we put quite a lot of different ways in which we say the US court had jurisdiction, that there's quite a lot of open questions about what approach the court would take under the new law. And we put it in relation to Mr. Ravindran 8 different ways, which you'll find on page 8 of the bundle at paragraph 22. So this is only a complaint about one of those ways. But in any event, it is a bad point, because as we understand it, the assertion that is being made is that the jurisdiction challenge has not yet been decided. So in other words, somehow the US court has given a judgment, a final judgment, but then said, oh, but we'll decide jurisdiction later. It's a wholly illogical argument. And the bottom line is that Mr. Ravindran has argued the merits. No one can deny that. And we say never challenged jurisdiction. And that's addressed by Mr. Hranitsky. If you need the references again, I'll give you them. It's page 6612 of the bundle, paragraphs 47 to 50. And Mr. Van Tol makes no response to this. And you can see it from the pleadings in the United States as well. And I'll just show you one page of that, 2 pages maybe. If you go to the prayer for relief that was advanced by Mr. Ravindran, page 1614. And you can see the positive defences that he advances. And then goes down all the way to 1616. He requests positive relief. Ravindran respectfully requests that this court enter judgment for Ravindran and against plaintiff. So he's asking positively for a judgment on the basis of those defences. So those are the 5 points that are raised in the statement of case. We now have 2 more points. The first one, and I'll deal with them briefly if I may. The first one is the point about Nadil and Lemiere. That's the one that we raised at the ex parte hearing. It doesn't appear in the application, and it isn't an argument for jurisdiction over the claim, because the claim is for enforcement of a foreign judgment, and that was dealing with jurisdiction to grant a freezing order in support of foreign proceedings. Nadil and Lemiere, you've not really been shown. I'm not going to go through it in much detail because you haven't really had any submissions on it at all, frankly. My learned friend speculates that the Court of Appeal may not have overturned it. That is wrong as a matter of record. Now, the Court of Appeal has not given judgment, but they have overturned the judgment, because the judgment was a judgment refusing relief on the ground that there was no jurisdiction. And so the DIFC Court of Appeal has overturned that decision refusing relief for one reason, which was sufficient for those purposes, and is considering the second reason at the second phase, which is whether or not finally it's to be decided that the DIFC Court's jurisdiction exists, absent assets or an entity in the DIFC. So it is right to say that it is, in one view, an open question as to whether or not the DIFC Court has jurisdiction of this sort, the Carmen jurisdiction, if I can call it that. But it is totally wrong to suggest that Nadil and Lemiere hasn't been overturned. It has been overturned by the Court of Appeal. The fact that the decision is not on the website is nobody's fault, but it doesn't affect what happened.
I am aware of the Court of Appeal decision.
My learned friend said what's good for the goose is good for the gander, but in the sense that he was saying one's under appeal and the other's under appeal. But there's a complete false equivalence, because one is the question of DIFC law. What is the legal position? Is there a primary judgment that you're bound by? You would never be bound by it anyway, because it was a first instance decision. But the convention would be you'd follow it unless it was obviously wrong. But it has completely been overturned, so it is not authority in the DIFC at all. Now, I gave Your Honour a short explanation for why we say the Court of Appeal will find that there is jurisdiction. I wasn't going to expand too much on that, but just dealing with the question of the actual first instance judgment, what you will see when you go through it, if you do, is you will see that it doesn't deal actually with the gateways that we rely on today, and indeed didn't deal with the gateways that were relied on in that case. What was identified as being the jurisdictional gateways relied on, you'll see at paragraph 13 of that judgment, was 14A7 and various other places, but never 15.4 or 31.4. Now, in fairness, the judge did go on to say, well, you do need assets or something akin to assets in the DIFC. But it's very difficult to understand that conclusion when one actually looks at the language. The only hook, sorry.
Well, the words, did hang on the words inside the DIFC?
Yes, quite.
But that, as a matter of syntax or grammar, seems to be referring to enforcement within the DIFC, not some sort of requirement for the judgment that's to be enforced.
For the assets, correct.
For the assets, sorry,
yes. No, that's the answer, and that's always been the answer, because the same language appeared in Article 7.6 of the Judicial Authority Law that preceded it, and so and it was beyond argument, although it was argued many times in many ways, that there was no need for there to be assets in the DIFC in order to enforce a judgment in the DIFC. It's a bit like the forum non conveniens argument in a way, in the sense that, of course, the DIFC court is enforcing in the DIFC because that's what the DIFC can do. Now, what the consequences of that are subsequently is a matter for the local courts. But what all the DIFC court is doing is enforcing in the DIFC a foreign judgment. And then the question is there some other requirement? So I wasn't going to labour that unless you want me to.
No, I think it's well-trodden ground.
Thank you. All right, and then what is left? There is this argument that the preliminary injunction has ceased to exist. Now, this was mentioned at the end of the submissions this morning. It does appear in the skeleton argument in this section. Actually, in the application, it's made in support of setting aside the proprietary injunction. But I was going to just deal with it now anyway, because it's got to be dealt with one way or another. Now, this is an area where you've been provided with a little bit of law. And essentially, as we understand the argument, what is being said is this. Number one, preliminary injunctions dissolve when the court rules on the merits. Number two, the court has ruled on the merits in the summary judgment and in the summary judgment order. And three, therefore, the preliminary injunction has dissolved. That's the sort of basic steps in the argument as we understand it. And the short answer to this point is that the court in the US has not ruled on the merits of the claims on the basis of which the preliminary injunction was granted. So the position in the United States is that some of the claims, some of the counts, as they call them, have been resolved, and some of them have not. And we will, and I'll show you this. What the US law says is that the preliminary injunction dissolves if the counts on the basis of which the preliminary injunction was granted have been resolved. That's the point at which, if you win, you need to get your permanent injunction. If you lose, your provisional injunction goes away. So that's the basic point. And actually, when we get to Mr. Van Tol's response, you'll see there isn't an awful lot of dispute about the law here. What is the law in the US? That there's just quite a lot of sort of retelling of history, frankly, about the basis for the preliminary injunction in the first place. So first, the law. And I'm going to show you a couple of cases from the US, if I may. They're in the main bundle. And the first one is the International Union case, which is at 7541. And you can see what this case was about. The defendants, this was a dispute between a union and an employer and its shareholder. And essentially, from paragraph 1, you can see that the focus of this particular opinion, 4 lines down, it was they challenged the company and its shareholder challenged the district court's issuance of a preliminary injunction and its denial of BPP's motion to dissolve the preliminary injunction. And you've got the facts in paragraph 1, but I can just describe them for you if that's all right. Essentially, yes. What you've got is a union which sued a company and its shareholder for obligations which were due to the company's former employees. So there were things like pension rights that were going to go on for perpetuity, but the company was proposing to essentially repay all its unsecured creditors, and that would leave it with nothing and wind up its operations and leave it with nothing. So there were 6 counts advanced in that case. And you can see the first one, the bottom right corner of this page here, 4 lines up from the bottom. A claim for breaches of its obligations to provide lifetime healthcare benefits for retirees in excess of 4.7 million, count 1. And then there are 5 other counts. And you will see if you go over the page to 7542, at the end of paragraph 2 of section 1, just that in that final paragraph, you can see 4 lines up from the bottom. BPP again filed a timely notice of appeal from the district. They obtained a preliminary injunction prohibiting the transfer of the company's assets. And then at the end of paragraph 2, you can see that the company appealed against that. And you will see there, importantly, there's a footnote to that. footnote 1. And we have to go to page 7544 to see the footnote. And then it says, on September 29th, 1997, the District Court granted the union's motion for partial summary judgment with respect to its claims to retiree health benefits, count 1. The District Court found that BPP was obligated to provide lifetime healthcare benefits to all BPP employees who retired after the 1st June 1985. And then they say this: we do not believe that the District Court's grant of partial summary judgment makes this appeal moot. And then goes on to say the order of preliminary injunction is still in place and the District Court has only ruled on a portion of the merits of this case. And in his latest statement, I think what I'll do is, rather than go through every authority that we rely on, I'll show you what Mr. Van Tol relies on. Mr. Van Tol's latest statement you will find at 8417. But if we go, please, to page 8425, you'll get to the relevant part of it. And it's paragraph 35, and this is in Mr. Van Tol's evidence for today.
35.
Yes, please. He says, therefore, in the context of Rule 56, a preliminary injunction will dissolve if the summary judgment or partial summary judgment decides the merits of the claims covered by the injunction. So I'll come on to explain a bit more about the cases that he relies on, but essentially that is not inconsistent with what we're saying, which is that you have to look at what is supporting the injunction and ask the question, has that been decided? And that is effectively what is said in the two cases that he then cites. So you'll see he cites two cases, CFI, and then a little bit further down a case called ProEdge. So I'm just going to show you a couple of passages from those two cases, if I may, just to show that they support me. CFI you'll find at 8449.
Sorry,
8449. So these are the authorities produced by Mr. Van Tol. And you will see that what this is essentially a possession claim, in effect, for land in Hawaii. You see that from paragraph 1, just from the first few words. It's about land in Maui. And the claimants raised 7 counts. And they sought summary judgment in relation to 3 of them. You can see that at the top of the second column on this page. Plaintiff seeks summary judgment of 3 of the 7 claims. Do you see that?
Yes.
Plaintiff seeks summary judgment on count 2 for quiet title, count 4 for ejectment, count 5 for remedies, including a permanent injunction. And so then they go through the various counts, but the substantive claims were in 2 and 4. So over the page at 8453, actually, you'll see bottom left of this, 8453, count 2 is described as quiet title. And you see at the bottom of the page, in an action for quiet title, the burden is on the plaintiff to prove title to the land in dispute. And an 8457, after some consideration, the court then grants summary judgment in relation to that count. That's count 2. And then you have it's 8457. You'll see it on in the second column at the top right. It's the end of paragraph. And then you see count 4 for ejectment. And then that's the second substantive count on which summary judgment was sought. And in the middle of the page, you see plaintiff's partial motion for summary judgment as to count 4 for ejectment is granted. And then they come on to consider count 5. And it's in that context, in count 5, that they say, and under the heading count 5 request for remedies, they make the point at the bottom of that first paragraph that is a request for remedies and not summary judgment as to a cause of action. And then you can see the way that it was argued at the top of the next page. And this is significant. So they say, plaintiffs assert in their motion for partial summary judgment that if they prevail on summary judgment for their quiet title and ejectment claims, they are entitled to an injunction to prevent defendants from claiming title to their property and from entering their property. So the request for the injunction was based firmly on counts 2 and 4. And it's in that context, just under the yellow highlighting, if I can ask you to look at that, a preliminary injunction is not procedurally appropriate for plaintiffs as they have prevailed on summary judgment as to their quiet title and ejectment claims. So that's consistent with the principle that we're suggesting applies. You look at the counts on which the injunction is sought, has been ordered, and if those are yet to be determined, then the preliminary injunction remains in place. The other case is Pro Edge, which is on the same lines, but I will show it to you if that's all right. It's at 8438, so just a little bit further up.
Yes.
Sorry, it starts at 8434. I do apologize. And you will see that this one was a claim to enforce restrictive covenants in a contract. And one of the issues was that an injunction had been obtained and a bond had been granted to support that injunction, and there was an application to enforce on that bond, and the question was whether or not the injunction remained in place or whether the application was premature and it remained in case, or whether the injunction had fallen away. And you will see at paragraph 3, really the nub of it on this page. Motion to recover on preliminary injunction bond was not premature before entry of final judgment, and this is the important bit, where preliminary injunction had been dissolved upon entry of partial summary judgment in favour of enjoined party on count underlying injunctive relief. And 8438. The next bit and the last bit of this judgment, which is, just to remind you, so the defendant was seeking to execute on a bond given to support an injunction. The question was whether the injunction had been discharged. There'd been summary judgment on count 1 in this, and the plaintiff was arguing that they could hang on to their injunction because they'd also sought it on counts 2 to 5. And the answer is in paragraph 3 here. So I think it's about 8 lines down from the top. The plaintiffs overlook the fact that although they may have requested preliminary and or permanent injunctive relief with respect to counts 2 through 5, either preliminary injunctive relief was not sought on those counts or sufficient evidence was not presented during the preliminary injunction hearing because preliminary injunctions on those grounds were never obtained. The only preliminary injunction that has been issued throughout the course of this lawsuit pertained exclusively to count 1. We can skip down to about 5 lines down. The simple fact that injunctive relief was requested but never obtained with respect to the other counts asserted in the complaint does not somehow justify the injunction that was actually issued, which prevented Dr. Gu from only violating the provision of the covenant not to compete. So the question in this case is, what are the counts on the basis of which this preliminary injunction was issued? And the counts to have in mind for this process are 1, 2, and 7, and I'll show you those in a minute. But essentially, the fraudulent transfer case was counts 1 and 2. Actual fraudulent transfer was count 1. Constructive fraudulent transfer was count 2. And then there was an accounting claim in count 7. And I can show you that if it's at page 1465. And I'm sorry, I've got the wrong. I've typed in the wrong number, that's why. So I'm giving you the wrong reference, but it is 1465. There we are. And at the bottom of that page, you can see causes of action, count 1, actual fraudulent transfers, and that count is advanced against all the defendants. And then 1469, count 2, constructive fraudulent transfers against all of the defendants. Now, there was also an accounting one. This is of less direct relevance, but I'll just show it to you. It's at 1484. And it's count 7, accounting. And that includes against Byju Ravindran. And it's right to say that this is the second amended complaint. So this is in a slightly different form to the one that was put before the court for the injunction. But let's look at what the court actually said it was basing its preliminary injunction on. If we go to page 1371, we get to the opinion. I think Your Honour has read this at the ex parte. This was the opinion for the provisional preliminary injunction, but the relevant part of it is at page 1384. Well, I'll take you through it a little bit. If we go to 1384, there was an argument about whether or not it was necessary to have an equitable claim to support an injunction in that jurisdiction, or whether there could just be a money claim, a debt claim. And in this section of the judgment, the court was essentially saying, here, preliminary injunctive relief could be granted in support of the fraudulent transfer claim, such as the one that was pleaded by the claimant, and I've shown you it, in a number of different circumstances. Firstly, if the state's laws provided for prejudgment attachment, which it says it does under what's called the DUFTA provision, or secondly, if the plaintiff seeks damages for a fraudulent transfer and also raises equitable claims, which he found they did in the form of breach of fiduciary duty and accounting, the breach of fiduciary duty being count 4. So then at 1385, they refer to the judge refers to the breach of fiduciary duty claim, and then in the second paragraph says, halfway down the page, although the debtor does not specifically use the word accounting in its complaint, I'm satisfied that it has pled a request for accounting, such that the equitable remedy sought by the debtor is appropriate here. So you'll see in Mr. Van Tol's evidence suggestion that there was no accounting claim at this stage and it came later. It's right, the word accounting was not used at this stage, but the judge says there's accounting. But this is one of the 2 bases on which he says, well, I can make an order in support of the fraudulent transfer claims. Firstly, there's DUFTA. Secondly, the fraudulent transfer claims are supported by claims for equitable relief. And then paragraph 1386 records that. You'll see the final page, 1386, the final paragraph. He records those 2 different ways in which he has authority to make the injunction sought. And so then he goes on to ask the question over the page at 1387, was the relief warranted in this case? And you'll see at page 1388, the reason why, the beginning of the main paragraph there, the debtor has shown that it has a reasonable probability of success on its fraudulent transfer claims, and goes through all of the evidence on that. And then in the second to last line says, the defendants have not presented a single piece of evidence to suggest that the camshaft transfers were made for any reason other than defrauding the debtor's creditors, I find that the debtor is reasonably likely to succeed on its claim for actual fraudulent transfer. And then over the page also goes on to say the debtor is reasonably likely. Sorry, that's the final bit. But then the footnote, the judge says, even if the debtor does not prevail on actual fraudulent transfer, it's reasonably likely to succeed on constructive fraudulent transfer claims. So that's the basis of the order, is those two counts 1 and 2, actual constructive fraudulent transfer. So what was decided in the summary judgment order, we can see that the order starts at 2587. There's quite a lot of preamble, and then 2588, you'll see paragraph 2 starts to explain what relief is being granted here. And the important thing to note is paragraph 2 says, judgment is hereby entered in favour of plaintiffs against Camshaft Fund as to count 1 of the second amended complaint. And then paragraph 3, judgment is hereby entered in favour of plaintiffs against Inspire Learn and T&L as to count 1 of the second amended complaint. 4 then deals with the fiduciary duty claim, and then there's other particular counts for 8 and 10 which deal with the second fraudulent transfer. So the upshot is that as against Mr. Ravindran, against whom this injunction is sought to be enforced, neither counts 1 or 2 have been decided. The accounting claim also remains unresolved, but the primary basis for the order was counts 1 and 2. So where does that take us? Well, on the authorities that I've shown you, it's pretty clear the preliminary injunction remains in place. Mr. Van Tol's response to all of this is 8426. And I just need to show you a little bit more, but there's probably another 5 minutes or so, 10 minutes maybe on this. 8426, he makes 3 points. I don't think I need to trouble you with a third of those because it's got something, I don't think really bites on what we're discussing here. But this first point is, he says the actual fraudulent transfer claim is duplicative and unnecessary because they've already found against him on another theory of liability, breach of fiduciary duty. So I think the point there is that he's saying there's no point in the fraudulent transfer claim. And then he goes on to say it's not based on the accounting claim. But the preliminary relief, the preliminary injunction, was based on the fraudulent transfer claims. And of course we need it because if we don't have an injunction against him, then he's not restrained. So we don't currently have final injunctive relief in relation to anything that has been decided. So of course we need the claims that have not been decided. And those are proprietary claims, or at least claims that are capable of supporting the proprietary order that we've advanced, that we've obtained. One point to note here is that it doesn't look like Mr. Ravindran is making this argument in the United States. And because he's subject to contempt in the United States, he's subject to a contempt order. And you can see that at page 1888. And it's paragraph 1. And paragraph 1 says Ravindran is in contempt of court for failing to comply with this order. And in court in the United States, Mr. Van Tol has confirmed that Mr. Ravindran remains under the contempt order. you'll see that at 6957. And at 6957 at the top of the page, Mr. Van Tol confirms that Mr. Ravindran is subject to that contempt order. He says Mr. Ravindran is still under a contempt order. We plan in short order to come to Your Honour to get that contempt order lifted on the basis, based on the fact that he has been providing and will be providing discovery on assets. And that, we say, is only logically consistent with the provisional or the preliminary injunction continuing. And indeed, Mr. Van Tol appears to accept the logic of that as well in his evidence. So I'll show you that. That's at 8429. Paragraph 56 of Mr. Van Tol's witness statement. He says, Mr. Rene also says that it is not correct that the Byju contempt order fell away when the bankruptcy court entered the US SJ order. However, the Byju contempt order was inextricably linked with the US preliminary injunction, and if the latter ceased to have effect upon entry of the US SJ order, the former must also fall away. So he accepts the logic that you can't have one without the other, but and then is driven to arguing that somehow the other has fallen away, and yet in the United States he's not brazen enough to make that argument in front of the judges in the court where the order has actually been made. So the logic is sound. He accepts in the United States that the contempt order continues to have effect. The logic is that they're inextricably linked, and therefore it's very difficult to see why they would be telling you, Your Honour, that this preliminary injunction's fallen away when the logic of their position in the United States is completely the opposite. So that's what we say about that issue. There was this vague allegation that there's no assets or connection with the, quotes, jurisdiction, and that extended to making assertions about what Mr. Ravindran has in practice in Dubai, what his connections are with Dubai, rather than just the DIFC. I think for now, it's sufficient just to say there's no specific requirement for that. That all comes at the next stage, set-aside stage. But we do take issue with the points, and I think you'll probably have this. My own friend said that Mr. Ravindran was visiting Dubai on holiday. We do say that's completely false. It's just not true. And I'll deal with that in due course, but I'll do it, I think, in the next stage, if that's all right. Okay. He also said Mr. Ravindran has no assets in Dubai. We know that there are some bank accounts. We also know that there were some courts over $10,000 by the order which have been depleted, and I'll come on to that in due course. There was one in particular which had, he said, $16,000 in it, but by the time we get the next statement, there's nothing left, or at least there's nothing that it's under $10,000. But you've also heard my own friend's submission, which, I mean, he appears to be taking the position that if the money that Mr. Ravindran holds is borrowed money, then it doesn't need to be declared. That is
I'm not sure I understood it, really.
It doesn't make any sense, that's why. So if I borrow $1 million from a bank, or indeed my friend, or indeed somebody who might be associated with this alleged fraud, if I borrow $1 million, what do I have? I have an asset of $1 million sitting in my account, and I have a debt liability to somebody else. The asset sitting in my account is not in itself a debt, it's money I have. And so I have to declare that $1 million. Now, it sounds like Mr. Ravindran is receiving advice that he doesn't need to give that declaration. And that is hugely alarming for a whole range of reasons. It probably would help to have the courts clear statement as to that in due course, whether it's now or later or whenever or in a judgment. But what that means.
Well, I thought I put to Mr. McNutt in trying to understand what he was putting, the proposition that the example I gave him, if Mr. Ravindram borrowed money from a bank, the bank loaned money to Mr. Ravindram. If Mr. Ravindram received that money and deposited in a second bank, his deposit in the second bank is an asset, and the debt he owes to the first bank is a liability. And I'm not sure that Mr. McNutt disagreed with that, but he might.
He did.
Did he? Well, he might explain it to us again. In a while, Mr. McNutt, we'll get you to tell us about it.
We would say that it doesn't matter where he deposits it. If I borrow money from a bank, I may have an obligation to repay that, even if it's a payable on demand.
I took that example because, for example, it might be more complicated if you've got a facility but not actually drawn down on it or something like that. But
yes, I see. All right, very good. But the point I was going to make was all of these assertions that there are no assets in the jurisdiction. We'll come on later to see whether or not anything that Mr. Ravindran says about this stuff can be taken on as read. But there is real concern if the advice is being given that the money that is held pursuant to a loan doesn't need to be disclosed. It's troubling. But that does sound like what is being advised. Your Honour, those are my submissions on jurisdiction. Is there anything else that you want me to address? Sorry.
Not now. We'll go back to Mr. McNutt.
Thank you.
Well, just one comment. The reason I raised my hand a few moments ago is he says, my good learned friend said something to the end of his discussion about the proprietary injunction. He said, well, now that we've nailed that issue, I don't know what issue he was talking about because it had nothing to do with jurisdiction. That's a set-aside application issue that he prematurely brought for the court when I was supposed to go first. So I appreciate him having already made his defense to you. But I would say, therefore, that we've kind of flipped the horse on the set-aside, and that's okay. We've done that. Concerning this allegation of being, quote, troubled that he's getting poor advice, that's absolute nonsense. The transcript will reflect that Your Honor and I were debating different types of assets. And I said, well, if I take it from an accounting perspective, if I take an asset, of course, basic accounting, you take a loan, as you said, it's called a T account. In accounting, you've got an asset liability. You borrow money, that's one asset or liability. That money goes in your bank, that's an asset. I agree with Your Honor that if you have a line of credit, and you haven't drawn on it, that's a contingent potential asset. I'm not going to accept a mischaracterization of what was said by my good learned friend here, that we somehow have indicated that our client has some advice to not declare borrowed funds. That's ridiculous. What I said was, if you borrow a car and you don't hold title to it, you just borrow somebody's car, it's not an asset. It's not an asset.
I think we're going to understand that, but the context in which this matter arises was funds in bank accounts. And I think the way in which it came up, Mr. McNutt, was you made some reference to transferring money into a bank account in Dubai. That's the context, not other assets.
That's right. And the context of that actually was that this travel ban, because he doesn't live here, he lives in India. His father is here getting cancer treatment. He's placed in the unfortunate position that should he visit here and need to pay for a hotel or something else, he has an existing bank account of limited means which the duration of the freezing order will have already depleted 100% of the value of that account. And consequently, should he deposit money into that account to pay these living expenses up to 10,000, he doesn't have to declare, but thereafter he would have to declare. It creates a problem. We were discussing the problem of the abuse of the travel order, and I simply said yes. And if he has to transfer money, and we have a second problem, because if he doesn't, he transfers €1 into this account because they registered the interim freezing order as a permanent freezing order. There is no carve out for the living expense. Consequently, he never can transfer money here to visit his father and do what is normal. And the reason he can't do that is exclusively due to the abuse of the claimants and how they registered in the local courts. And that was the context.
When he made his disclosed his assets, did he disclose bank accounts outside of Dubai holding substantial funds?
Let me check the value he declared. 1 second, let me check it.
Just give me a page.
1 second, please, John. I'd rather be precise on this because one man's limited amount of bank account might mean quite a difference to another man's bank account, right? So I think that matters, right?
5371.
5371 in the bundle, please.
5371.
Yes, please.
So standard application. And you come down.
1373,
And we continue down to 5373. He discloses the bank account in India where he lives. I don't know the exchange rate, forgive me, of 63 million rupees. Yes. I'll have somebody run a calculation. Give me 2 seconds. 2 seconds, we'll see what the rate is today. And when we get to this part of the asset issue, it should not be surprising. What is surprising to me is that you think he has assets. Yes, please.
Yeah, that's the asset you're, sorry, how much is it?
$750,000 approximately.
Approximately $750,000.
Oh, okay. So he does have money outside of Dubai.
Well, and that's the point. He lives outside. And so he is not, the problem is not that he has money. He doesn't have 540 million. And what's offensive and disgusting is they know he doesn't have it.
75.
Sorry, 75,000, not 750,000. They know he has money. They know that he's borrowing money. They know that 533 million went to OCI. They know that is pursuant to, this is all disclosed in the US. That's what is astonishing, that there's this claim that somehow we're so confused where this money went. It's a joke. It's a joke. And I can't wait to run you through that. We're on jurisdiction right now, and I want to get back to jurisdiction because what I would ask, I was thrown in the course of this about, I think, 50 different legal citations and whatnot. Can I kindly ask for 5 minutes just to get my citations right to respond and reply to this, Your Honor?
All right, 5 minutes. Mr. McNutt, are you back with us yet? Can somebody from the defendant's legal team please tell Mr. McNutt that we're waiting for him?
I'm sorry, 1 second, please. There we go. Thank you very much.
All right.
Apologies. I won't explain. Sorry, I'm back.
Okay.
Thank you. So, first of all, thank you. I want to say thank you to my good learned friend. That was very useful to help see where some differences are and where we get along. So that's good. I'm a big believer that if we can mitigate the dispute to get to where we agree, we can then put things in front of Your Honor that really need to be done. One correction on the money, the exchange rate is $719,000 was in the account, not 70,000 or whatever I incorrectly said. And I just want that on the record that I misspoke and I wanted to correct that. Thank you. Secondly, and I'm going to need some help from Your Honor on this. The last discussion about the set-aside application issue concerning jurisdiction, concerning proprietary injunction was rather long. And so a number of the points raised by my good learned friend related in fact to that. And I want to make sure that we have a good use of time, given the fact that it's 3:20 now. I want to make sure we get jurisdiction like gone. So I'm going to present a fundamental issue, and then I would respectfully ask Your Honor to help guide me on any jurisdictional things that he raised so that I don't get distracted by the set aside. And then we can dispose of that today. I'll try to do it on my own. But I have to be honest, the last 15 minutes, a lot of those arguments weren't related to the specific arguments that related to the jurisdictional challenge. So I want to address in particular this argument that Article 15.4 was not dealt with, right? So at the very beginning of all this, he mentioned there were 4 tests. And tests 1 and 2 were clearly in the jurisdictional challenge. The third one was this Article 15.4. And then the fourth one was this UNSA trial issue, which I had previously addressed. So I'm not going to waste our time on that. What I would like to do, though, is to please refer you to the actual claim form, if you don't mind. And that claim form is at bundle, one moment, please. Page 4 of the bundle. Now, again, we're talking about ex parte versus continuation, right? So I'm a believer on the procedure side.
Wait a minute, sorry. We're talking about
jurisdiction.
You brought up the claim, but the particular application you're referring to is your application that the court does not have jurisdiction in respect of the claim to recognise and enforce the judgments, not the application for a freezing order and proprietary injunction.
Yeah, I agree. That one would be a merits issue, one would be a jurisdiction issue. I agree. Now, but I do think it's relevant.
No, I'm sorry. I think that
okay,
wasn't what I was saying. All I was saying was that the jurisdiction application that you have brought is in terms an application, as I understand it, that the court does not have jurisdiction in respect of the claim that has been filed, that is the Part 7 claim form.
And that claim form is what I'd like to look at briefly.
Okay.
Correct. You're 100% correct. And remember the burden of proof obligation here is not on us, it's on claimant. So, and that's why I'm bringing this claim form up. So the claimant approaches the court with this claim form and very clearly is presenting a Part 7 claim. If you look at claim details on page 3 of the bundle, right? So we agree it's a Part 7, that's great. And then it refers to their particulars of claim down in the next section, fantastic. And it seeks, and this is really important, paragraph 3, it seeks recognition and enforcement of the U.S. summary judgment, which is what we're talking about, whether that's a final judgment or not, and then whether or not the second Roman 2 is a final order or not. And then we relate to this preliminary injunction, which they're asking to recognize a preliminary injunction under Part 7, which is impossible. It's impossible. And the reason is, 1 second, please, I'll explain why. Now, that injunction, by definition, is in aid of a foreign proceeding and is argued by claimants to remain in force in aid of that proceeding while claims are being disposed of. No different than the claim in 5.1 that in aid of proceedings against defendants 2 and 3, they're seeking a freezing order because they want to aid those foreign proceedings. So here, this injunction is under the premise to aid that foreign proceeding. It's not aiding proceedings in the DIFC. It can't aid things here because it's a preliminary injunction related to counts not yet determined, according to my good learned friend. If they were counts that were determined and it was a final injunction in the States, I agree 100% it's under Part 8. Excuse me, under Part 7, forgive me. But it's not. It's clearly in aid of a foreign proceeding, in aid of future claims or current claims not yet resolved. That's their submission, the last 15 minutes. So then we go to the other details, which is quite relevant. It's a default jurisdiction. If it wasn't Part 7, if it was a Part 8, it would say you have to opt in or opt out. So we know for sure it's a Part 7. There's no doubt there is in aid of completed proceedings, not foreign proceedings that are ongoing. And then I go to and I'll show you why there's a problem with the relief they sought and why they never should have been granted the injunction in the first place. So when we go then to remedies sought, we've got recognition of the enforcement. Okay, that's good. That's Part 7. That's clear. Point 1. And then I'm trying to figure out where they can get from a Part 7 into a Part 8 injunction under the DIFC.
But they filed a separate application for the interlocutory relief for the freezing order and proprietary injunction.
Yeah, and where did they file that?
Well, that's in the book. That's in the bundle somewhere.
Yeah, no, my point is we say they filed it, right? So let's, because remember, his complaint was in our challenge, we didn't attack this 15.4 issue. So if we look at, I mean, it's a fact, the claim is a Part 7 claim. That's without doubt. And 31.4 applies in that instance. That's not debated. And then on the 20th of May, if I take us to the same citations as my good learned friend B89, sorry, bundle 89, he's referring to, 15.4 and 31.4 of the new law. And if you were to go back to the claim, you would see that other details, top of other details, they refer to only Article 31 in the claim form. All right. And that's okay. I understand it might be a formatting thing or something else. But then you've got the application that you just mentioned. Let's just look at that real quick, because my colleague pointed that out. That's bundle 324. That urgent application.
Mm-hmm.
Again, I'm not understanding the urgency of that application, given the fact they already have the relief in the United States. And if the PI is in place, if the preliminary injunction's in the States, what makes it more urgent in the DIFC if they already have it? So I'm not quite sure that even qualifies. But setting that aside, I'm just trying to look through here and see if 15 is actually mentioned here. And
I hesitate to interrupt, and I do apologize, but may I just make one observation?
Yes, go ahead.
I'm very concerned that my own friend's taking so much time in reply. He took a lot of time in opening and a lot of time in reply. I took about 1 hour and 15 minutes. My concern is that as a result of what is happening, it's going to be said that we run out of time for the collateral use application at the end of tomorrow. That's my concern, Your Honour. But I just make that observation. Leave it in your hands.
We'll watch it. Yes, Mr. McNutt.
If I look in this application, it doesn't actually mention Article 15.4 anywhere. Maybe I'm wrong, but I don't see it anywhere. So it's an urgent application. It doesn't argue 15.4. The primary application does mention 31.4. And I'm just highlighting for Your Honor that it doesn't mention the clause that they're relying on for this urgent application. And that you might think that's form over substance, but forms matter. And that's why we have these forms. And so if I think it's relevant because if you say that it's fundamentally a Part 7 claim that we're dealing with concerning Defendant 1, that it is a final judgment. And if claimant's submission is the preliminary injunction in the United States does not fall away because there's 2 counts still not resolved, then A, there's no urgency, and B, there's no they would need to file a Part 8 application in aid of foreign proceedings. We need the PI because we're not done with those proceedings. But they didn't do that. They cut a corner. They tried to bootstrap effectively a Part 8 ongoing matter injunction onto a Part 7 application. And Your Honor, I'm not sure if that's appropriate. That's why I'm asking that.
They can stand separately.
Well, I'm not disputing it can stand separately. I'm not disputing people can make applications. That's fine. But that's fine. And if you would like to say they stand separately, then it would mean that the ex parte hearing was technically should be fundamentally separate hearings, call it, because they stand separate. And they argue both at the same time.
Well, there was
I was talking about how we argue.
Yeah, there was no hearing of the Part 7 claim. The court hasn't heard the application for recognition and enforcement. What was heard in May and has been the subject of subsequently what's happened is the application you've got in front of you at 324 and 325. The court has not heard the Part 7 claim.
No, but what the court did was it decided that because of a final preliminary order, a judgment, assets should be frozen. We can agree on that, right? That there was an understanding, there was a final judgment, and as a consequence, the assets were frozen. Are we in agreement on that?
Not quite. The court found that there was a good arguable case, and the good arguable case can be based on either an existing judgment or, for example, in the case of the defendants in CFI 050, it was based not on there being an existing judgment, but upon a judgment that the claimant had a good arguable case that it would obtain and then register.
Well, and you've highlighted a really important point that I referred to much earlier, which can't be escaped by a claimant. The fundamental difference is that a Part 8 application is an aid of ongoing for a future judgment, and a Part 7 relies on a statement of fact. And what my good learned friend is saying is, no, you don't have to rely on that fact. You could apply a different test and allow the DIFC court to determine itself, and you raised the point, Your Honor, when you were discussing it, my good learned friend, that whether or not the DIFC court would have to decide if there was, in fact, a final judgment. And I'm saying,
well, this court, I'm not sure if you're saying something different from this, but this court has held in the past that it can grant a freezing order where there is no existing judgment, but the claimant has a good arguable case that it will obtain a judgment. That's the case. That's what the court found in relation to the defendants in CFI 050. The court granted ex parte, or without notice, granted the freezing order against those defendants in circumstances where there was not, and it was not claimed there was any judgment against them, but the court held that it has jurisdiction and may grant a freezing order in those circumstances.
Yeah, and I agree with that, because that application was made as a Part 8 application.
Yeah.
Right. And I'm 100% in agreement with Your Honor in doing that. And I'm 100% in agreement with Your Honor issuing a freezing order under Part 7 if there is a final order at the ex parte.
No, the court doesn't issue a freezing order under Part 7. Part 7 was the claim form. Then there was a Part 8 claim, and the claimant brought on for hearing its urgent application under the Part 8 claim for freezing order and proprietary injunction. The court,
yes, but it did not bring the Part 7 into the Part 8. That's, I think, where we don't. Maybe I misunderstood, but yeah. 51 clearly is a Part 7. I think we can agree on that.
Well, and there is a Part 7. there is a Part 7 claim in 51. There is also a Part 8 claim in 51.
Oh, excellent. Can you please ask my good learned friend to show us where a Part 8 claim is inside the Part 7, because I don't see it anywhere. That's the problem.
I don't know what you mean by inside.
So
claim.
when you bring the claim under Part 7, it is a consequence of having a judgment. That's the material difference with Part 8.
Well, no. Part 7, the claim, I mean, Part 7 and Part 8 are two different procedures for commencing claims. The Part 7 claim is a claim for the court to recognise and enforce a judgment. The Part 8 claim is different. The Part 8 claim is a claim to, the Part 8 claim is a claim for the freezing order and proprietary injunction. They're different claims. For example, as I've said, in CFI 050, there is a Part 8 claim and no Part 7 claim. That's referring to the initiating process. But to put it another way, a party can claim and the court can make a freezing order, even though there is no application for the recognition and enforcement of a judgment, because there is no existing judgment.
I agree. It's okay. It's just later in the day. It's a communication issue. So that's okay. Let me try it again. So
Okay.
I think we can agree that a preliminary injunction in aid of ongoing proceedings would be under Part 8. Do we agree with that?
I don't know what it means. I understand, I think what you're saying, the preliminary injunction granted by the US court was an order made in relation to existing proceedings there. In that sense, it's in aid of other proceedings.
But the claimant argues it's in effect because it's ongoing for ongoing proceedings. Yeah. Right. No different than case 51, which we just spoke about. Yeah. And that it's the same. One's merits claim against two defendants under 51, and one is an injunction for ongoing claims against defendant 1. And that's.
Can I put this to you, ask you this? It might be, for example, I might be persuaded that the court doesn't have jurisdiction to recognise and enforce the US preliminary injunction, but that would not have the result that I must set aside the proprietary injunction. I'm not sure if somebody else has got their microphones on. I'm hearing a bit of feedback.
No, I just want to understand it. So you're saying that even without a U.S. preliminary injunction, the court could issue a proprietary injunction?
It could.
Right. But that wasn't applied for. Will you agree with that, right? They applied based on the preliminary injunction in the U.S. And so.
Yeah, all right.
I'm sorry.
No,
go ahead.
What I was putting to you a moment ago was a slightly different proposition, and that is that I might be persuaded that the court does not have jurisdiction to recognise and enforce the US preliminary injunction, that might have the result that I should find that the court doesn't have jurisdiction in relation to that part of the Part 7 claim, which seeks recognition and enforcement of the US preliminary injunction. But that does not of itself mean that this court, did not have jurisdiction to grant the proprietary injunction.
I agree, and I'm taking the bite out of the apple step by step. So
Okay.
if I were to persuade you on that first point, which is what I'm trying to do, then we get to the question of under what bases would you issue the proprietary injunction if there was not recognition? I agree 100%. Thank you.
All right. Well, that's what we're on now, the set aside application. You say I should set it aside.
Well, and I'm saying that the jurisdiction, there was a query from my good learned friend, why in the discharge application did we not raise Article 15.4? That was where this all started, okay? And I'm saying, well, it wasn't raised for a very, very simple reason. 15.4 never applies to the question of jurisdiction for the recognition of the partial summary judgment. I think 15.4 never applies to that. Only 31.4 applies to recognition of the judgment. I don't think that's in dispute. And so 15.4, as a consequence, only would apply to the set aside of the precaution of the proprietary injunction. But my good learned friend had raised it in the discharge of the judgment, the four arguments of the judgment. And he had said, we hadn't raised it. And I said, of course we didn't raise it, because 15.4 never can apply to discharge a judgment under 31.4, because 15.4 never applies to judgments. It only applies to interim matters by definition. And so it is reasonable that we did not raise it in our in our challenge to jurisdiction application, because that application is not the jurisdiction of set aside. We do raise it, and we will deal with it on our set aside.
Okay.
And that's the only point I'm trying to make.
All right, I've got that.
Thank you. And I don't really think that was so much in dispute, except there was a question, why didn't we raise it? And it's that simple, because it doesn't apply to the challenge of jurisdiction on recognition. And then my good learned friend took you down this path of, well, Peter Van Tol recognizes the DIFC court could determine something different. And I'd ask you to look at, please, page 8423. And paragraph 25, which you were taken to, has been misapplied by my good learned friend. He is not saying anything other than what is required under New York bar ethics rules, which is, in contrast to Panitsky, who is bound by certain US bar rules, I offer no view on whether or not the retention in the US affects the ability of a foreign court. And the reason he takes no view is the New York bar rules prevent him from taking a view. You are expressly forbidden from taking a view in a jurisdiction outside of New York, except for certain limited real estate transactions in the United States. And it is not correct that he is saying, so as a consequence, do what you want in Dubai. He's not saying that. He's saying, I have no clue because I'm not a lawyer there. That's all he's saying. So it's incorrect what my good learned friend said about that. He said it in 3 different occasions when you review the transcript later. I then would take you, please, to Well, I'd like to take you first to the authorities for page 225. He referred you to.
Sorry, 225.
Claimants authorities 225. It was a Maidan order. Excuse me, I'm having trouble getting that page up. Am I correct? Maidan, is that what I say? 225. Yes. Authorities. Yeah, paragraph 39. So this, I just want to highlight, this is in relation to an arbitration award, not a court order, not a law. It's in relation to an arbitration award, not the application of a court order. And it was issued before the new law was issued. The new law has a specific reliance on 31.3 related to the recognition and enforcement of arbitration awards, not 31.4, which is the basis of their claim. So the citation to Maidan is incorrect. It doesn't apply in the instant case. If I look to the execution orders, 6606 of the bundle, paragraph, well, we'll just go ahead and walk down through 22. That's where you were taken to. He mentions in paragraph 22 that the U.S. order, and this is Kraninsky, I believe. He mentions, it says explicitly, it's plainly evident, enforceable. He ignores, again, my good learned friend ignores the benefit of the 7th May order that we talked about. He jumps, when he presents, he then later circles back to it, but he then agrees, and it's quite strange, he agrees that there is a debate as to when that order became final and enforceable, because he told you could be 14 days after, could be 30 days after, could be some day after. No, you didn't reference that.
That's just a misleading. That's just a misleading submission, I'm afraid.
Okay, what day did it become enforceable, my good learned friend? Tell me the day, in your opinion. I'm happy to have this debate in front of the judge. What day did it become enforceable? What exact day? I didn't bring up 14 days and 30 days, you did. What day is it enforceable?
You want to respond to that, Mr. Montague-Smith?
Yeah, it's enforceable on the day that it was issued, which is what it says in paragraph 7 of the order.
Yeah, because
the point that I was making, given that you've raised it, the point that I was making was not that there was any doubt about when it would be enforceable. There are different sets of rules which could have applied if the court had not made paragraph 7 of its order. If they'd been outside the bankruptcy court, it would have been 30 days. But by reason of the bankruptcy rules, which I showed you the reference to, you can go to it if you want, it was 14 days in that court because it was in the bankruptcy court. And so what the court was doing with paragraph 7 was saying, notwithstanding those rules, this order is effective immediately on issue. So to answer my friend's question, the answer is when it was issued. That was very clear.
Thank you.
Yeah, I agree. You made all of those submissions to prove the point that because the order expressly said immediately that it was that day. That was the whole point of that, going around it. It could have just as easily said it says immediately, so it's immediately, fine. But then we go to, after that, you go to the May 7th order, which I'm not going to read again, we've already done it, which was put in place to go to other federal district courts. And then Kraninsky shows you that by going in paragraph 25 to the writs, right? That's why he took you there. He first says it's due immediately, and because it's immediate, they could immediately go for the May 7th order. That's why the immediately was effective for that. And it doesn't say you can go outside the jurisdiction. It just says immediately, fine. So then the question becomes, where can you go? And you made these submissions about, well, we filed this stuff in these writs, and therefore it proves something. It doesn't prove something. It doesn't prove that it's final, like you said. It proves that under US law, when you have a writ, when you have a May 7th order, when you have that order, then you can go for your writs. That's why you didn't go for your writs after March 14th. You went after you got the writ, after you got the May 7th order, because you couldn't. That's why I had to wait. So you waited for it, and then you went for it. On May 7th, you got May 7th, and then you went for your writs. And that's the reason that it shows that. And then if we go to 8A, 1 second, please, I just need to get a citation.
Mr. McNutt, whilst you're doing this, and I'm looking at the time, I'm going to ensure that tonight, my time, this afternoon, your time, I'm not quite sure, it's just got into the afternoon for Mr. Montague Smith, we're going to complete the set-aside submissions. So I'd ask you to move as quickly as you can through the any remaining jurisdiction arguments and deal with the set-aside application.
Apologies. The citation I was looking for. Yeah, there we are. 8421, please. Just 1 second, please. Which paragraphs? Practical. Oh.
Back to 160 what it is. This continues with the latest.
Yeah. My good learned friend directed you to paragraph 17, and he said that isn't at all what Peter Van Tol said in his other declaration. But when you look back, and I'm not going to waste time tonight on it, we're fine, I'll move fast. But when you look back in the transcript and what was referred to, the paragraph preceding in Peter Van Tol's letter that he's referring to in paragraph 17, the citation provided by my good learned friend did not direct you to the paragraph immediately preceding that statement where he refers to the May 7 order. Okay, and we go back to the primary jurisdictional issue on this, which is if the claim is based on Part 7 for recognition of the award, judgment, and if there is no final judgment, then the representation that it was final at the ex parte hearing was incorrect. And we go back to 31.4 that if there is no final, and the argument, the order says it's final immediately, I could give you a French law order saying immediately in a first instance court, but that does not mean that it's immediately because of the other procedural remedies you're permitted. So you can't rely on the word immediately when you have the other evidence of it is not immediate when there is an appeal. And if we look back at 889, please. It'll take 1 second, I promise you. 1 second, one line, and I'm done with this.
What page?
It is Nick Marsh's, what is it? 889.
Yes.
The one that I was, mock's not probably the right word, but in 138, the functionally equivalent comment made earlier, it's his words. It's not my fault. I keep repeating it. It's his submission. It mentions that there's 3 tests, and the third one, that finding of good cause, and the reference to 214 is exactly the order I'm speaking about, right? If you look at so I appreciate the distraction of putting up DIFC law and all these other court orders, but you can't get around 138. There is an appeal. The time doesn't matter, the second one. And the issuing order of the 7th of May satisfies for U.S. purposes the ability to go to their federal district courts, but it does not rely on the word immediately to go outside of Delaware. That's why May 7th is important. So in order for this court to determine that a final order exists capable of recognition in the DIFC, it would have to interpret the May 7th order and look behind the interpretation to determine if it could be exported outside of what the order is designed for and what the claimants argue. And I'm simply submitting that I don't believe that this court has that jurisdictional right, and it would be outside the manifest powers of the court to interpret what a what a Delaware court firmly has the jurisdiction to determine. And the last paragraph you were sent to was paragraph 8 of that order. And it says, and we'll just keep it simple, we don't have to look at it. It says that the enforceability of the May 7th order, the enforceability of that order is in Delaware. And as a consequence, claimant was free to go before the court of Delaware and say, there's a dispute over the enforceability over in Dubai. Dubai doesn't have the jurisdiction to determine the enforceability of it itself because it's expressly provided for in the order. So we would ask you to please provide that interpretation, and we move for that determination from the court. Can we do that? And armed with that judgment, this court could easily apply the judgment because it is not looking into an interpretation. But in the absence of such an order, my good learned friend has said, well, maybe we could apply the common approach. Maybe we could, but I would love that if you could, because it would help me with maybe a lot of other cases. But unfortunately, in this specific case, that May 7th order doesn't let us do that here. It exclusively provides jurisdiction to that U.S. court to interpret the enforceability of its own order. And I think that in that sense, the jurisdiction claim, a challenge must prevail. No matter what we do with the set aside, that should prevail. And with that, I close on that and I'll move to the set aside. Thank you. And I apologize for that being a little more difficult to explain than anticipated. Sorry. I will mention one thing. We had proposed a hearing in person so that I could come to Australia as opposed to flying back last night from Paris here to be here today. So it's late in the day and I'm trying to make sure we stay focused to finish the set aside. I'm going to move quickly through the set aside, very quickly, to try to finish this off quickly.
Good. Well, I'm going to ask the court staff to sit on for a little while so that we can complete the set aside application.
Of course, sir.
Now,
thank you.
I would request the court's leave that instead of me presenting my argument for the set aside and then claimants replying, claimants have made their argument and now I'm replying. And I want to make sure I can still reply if they give any reply to what I said, because they've done it in reverse. And I want to make sure we're okay on that.
Yeah, you make your submissions, then after Mr. Montague-Smith responds to it, I will let you reply. Not repeat your submissions, but reply.
Excellent, thank you. I just don't want, when Mr. Montague-Smith replies, that he repeats everything he just said.
Well, I don't want anybody to repeat what they've already said.
Okay, great, great. So now, when we look at the jurisdiction, I'll work off of claimant's skeleton again instead of our own. We'll try to cut through the chase again on this, okay? When I look through that issue, I'm sorry, let me get the right page number. So that's paragraph 23 of his skeleton. And there are 3 tests that the parties agree listed in paragraph 24.
Yeah.
And as mentioned before in paragraph 25, he incorporates this ex parte from the ex parte skeleton. And that's, as I mentioned, we oppose that. But nonetheless, let's go forward. And then he lays out in paragraph 29 all these points about statement of claim, and point 2 in particular relates to the serious issue. All right. And then I'm going to jump really quickly through the jurisdiction to grant the proprietary injunction. So I want to make sure we don't make merits arguments and it's only jurisdiction arguments as to could the court grant it. And the issue is...
I'm sorry, I'm not sure I understand that. Your application is to set aside the proprietary injunction.
Yes.
On whatever grounds that you have sought to set it aside. And you're not going to get 2 goes at it.
No, I'm sorry. I didn't mean to imply that. I'm just saying for the sake of time. No. For the sake of time, I'm just trying to truncate the discussion. And just for the record, I agree we should make sure we finish everything by tomorrow, and we intend to do so as well. So I will get a good night's rest and perform better tomorrow. Leave it at that. The issue on jurisdiction is that the 3 tests have to be met in order for there to be jurisdiction. I think that's clear. The first test is serious issue to be tried.
I'm not sure Jurisdiction
Well,
is
that's
one of
his
those.
paragraph.
Well, Mr. McNutt, jurisdiction is one of those words that seems to be used by different people to mean different things. But by jurisdiction, I ordinarily understand it to mean the capacity of the court to hear the application. What is set out in paragraph 24 is the conditions which must be met for the court to grant the proprietary injunction, which is a different matter. But I don't know if it makes any difference. The point that's been said by Mr. Montague-Smith at paragraph 24 of his submissions, which I understand you have agreed with, is that the parties agree that for the court to grant the proprietary injunction, those three elements must be satisfied.
Yeah, and that's why I'm saying let's go right to the merits.
Yeah.
Because that's the longest part of this skeleton, and I want to get through that, and then I'll end with 2 minutes on jurisdiction. That's it. So if I go through call it the merits test, as it were, there's a debate whether, as you know, the preliminary injunction ceased to have effect or if it's still in force, right? Now, I think the argument is if it's still in effect due to pending claims, then it would be appropriate for the injunction to remain. Is that not your understanding, Your Honor? That's my understanding of their submission.
Say that again.
That if the preliminary injunction remains in the United States to determine those pending claims upon which the preliminary injunction was issued, then it would be appropriate for the proprietary injunction to continue here in the DIC. I think that summarizes the position.
Right.
Conversely, if it doesn't remain, there's a question, should there still be a proprietary injunction? And to do that, there would have to be a serious issue and the other two tests. So,
but one of the points that Mr. Montague-Smith makes, and I think it's somewhere in his section C3, is that the preliminary injunction is not the only basis for the proprietary injunction.
yeah, and and help me understand, what's your understanding of the other bases, if not for the preliminary injunction?
Well, he sets it out in paragraph 39.
Yeah, and what he says is the recognition and enforcement in the summary judgment that the funds remain the property, right?
Yeah.
So what if that summary order isn't final? Now I got to go back to this stupid final argument, right? So can we determine that the alpha funds remain the property?
What I have to be satisfied of is, and I'm not giving a judgment, but going back to what you and Mr. Montague-Smith agree is the test. Paragraph 24, first element, there is a serious issue to be tried on the merits. And that I might be satisfied that there's a serious question to be tried on the merits by whatever evidence is put forward by the claimant. It doesn't necessarily have to be a judgment, albeit in this case they rely upon the summary judgment findings and the evidence in support of it.
Yeah, I mean, I agree with you that if claimants wanted to submit other merits arguments to support that the ongoing fraud count one against Byju Ravindran in the U.S. courts has a good and arguable case for succeeding, I would agree that you could discuss the maintaining of the proprietary injunction. I agree with that. Unfortunately, they haven't done that. They haven't said we have a good and arguable case to
Well, that's what they
prevail.
say in paragraph 39.
No, they don't. I'm sorry,
right.
They don't say that. They don't say that. They simply say that the preliminary injunction continues. It continues because there's this count 1 pending and count 2.
Yeah.
They don't present a merits-based argument as to why. In paragraph 39.2, they don't say they have a good and arguable case for claims that continue. They just make a statement. If we prevail, in due course, we could get a judgment. I agree they made the statement, but they didn't make any merits arguments anywhere. They haven't said to the court that in order to prove, call it, the good and arguable case under 39.2, this is why we think we'll win. They've only said, well, if we win, great, and you can keep the injunction. I agree with you that if they made a good and arguable merits case under 39.2, you would be perfectly entitled to maintain the proprietary injunction. But they haven't done that. And in the absence of that, in the absence of proving to any degree, good and arguable, less than good and arguable, anything at all, there's no evidence before the court that they can actually prevail. All they do is direct you to 9,000 pages, of which probably 6,000 pages is Byju related. Another 1,000 pages relates to, for example, the Haler Declaration, where Haler is in a totally different adversarial proceeding that Byju is not even a party to. I might as well bring you some things in Mongolia and say, rely on that. It's cool. It's not even related to my defendant, but I'm going to go ahead and bring it. No, it's just not appropriate, because in 39.2, they're asking you to maintain the order based on 39.2. But if we agree, Your Honor, that they haven't presented any evidence on merits for 39.2, then they fall to 39.1. That's why I focused on 39.1, because for me, it's evident there's no arguments in 39.2. So that has to fall away. And if I rely only on 39.1, then there has to be a determination that the final summary judgment determines finally that the alpha funds remain the property of claimant's estate. But as long as the judgment is not final, there is no finality that the alpha funds remain the property of the estate. That's why it's critical there's an appeal, because in the appeal, we're arguing absolutely not. Absolutely not. That finding is disputed in the appeal. That the monies that were invested by Alpha into the camshaft fund, back-to-back lent, next day, transparently, next day, provided to OCI, and it's in the bundle, like that transfer from camshaft fund, where Byju was involved, to a third party, OCI, at that exact moment, Byju had no power to deal with those monies. And if you look at the proprietary injunction, paragraph 9, what does the injunction order? It says Byju is prohibited from taking any steps to A, B, C, D, funds of $533 million. But claimant doesn't dispute that the $533 million left Byju's control on the transfer to OCI. And consequently, the utility of the proprietary injunction doesn't exist. It simply doesn't exist. He cannot spend the 533. He cannot transfer the 533. He's not even a director that controls the LP interest. He can't go to OCI and say, give the money back. There's no evidence that he has any relationship whatsoever with OCI. So he can't spend it, he can't transfer it, he can't exchange it, he can't convert it, he can't dissipate it, he can't liquidate it, and he can't otherwise move or modify any rights related to it because 100% of that money is with OCI. And OCI is an independent third party for which this plaintiff has a parallel proceeding in Delaware against OCI precisely to determine what OCI did with the money, not Byju. And Byju is not a party to that pleading. If Byju was a party to the OCI proceedings, where they would be alleging that Byju somehow controlled the OCI money, I can appreciate an argument that somehow Byju could transfer, spend, convert, dissipate, but he's not. He's not at all. And as a consequence of that, the utility of the proprietary injunction doesn't exist. You might as well order him to be prohibited from spending any money in my bank account or your bank account, Your Honor, because he doesn't control it. And the premise that was put forth to you in the ex parte hearing was defective. Your Honor had to think for some reason that this defendant had some power to do some of those things. Otherwise, you never would have ordered it. And that's why I go back to the ex parte. That was not properly presented. Because if it was properly presented and Your Honor understood there was no ability for him to touch the 533, you would have said, I deny it because there is no there's no utility. It's useless. You have to demonstrate something with utility to request this. And they failed to do that entirely. Entirely. The point 2 of the paragraph 9, any funds transferred by Byju, he's not allowed to touch any funds transferred to a non-U.S. trust on behalf of Inspalearn. Well, Inspalearn is a subsidiary of Think and Learn. Byju is one of 6 at the time, now there's 3, suspended directors of Think and Learn. Alpha has the same judgment we're talking about. Alpha has a $540 million judgment that my good learned friend pointed you to, count 2 in the judgment, against Think and Learn and against Inspalearn. They have taken no steps to collect their money from Think and Learn. They've taken no steps to demonstrate how would Byju spend, transfer, exchange, et cetera, any funds transferred to a subsidiary of Think and Learn. Point 3, Roman 3, any funds transferred to a non-US subsidiary of Think and Learn. It's the same. There is zero utility to this proprietary injunction because claimant has no evidence to say that he could do anything. The evidence they do possess, which they didn't tell you, is Byju is a suspended director in Think and Learn, has no power in Think and Learn. The plaintiff, the 100% shareholder of the plaintiff is represented by Glass. Glass controls 99% of the Think and Learn creditor committee in India. Glass controls the resolution professional in India. Glass controls the resolution professional's ability to pay the $540 million summary judgment to Alpha. Glass controls both Alpha and Think and Learn and is taking no steps to offset the debt. Instead, it's harassing Byju, knowing he doesn't have the money. He doesn't have any of that money. In addition, they are saying, and they're failing to explain, if they collected the $533 million from Think and Learn, Byju has nothing to pay. They can't get double recovery on the 533. So they've told you they've taken steps against Camshaft. So if it's true you can grant a proprietary injunction without anything other than PI in America, the PI is still in force, then why is this application not made against camshaft? Why is this application for proprietary injunction not made against Think and Learn? If the argument is the preliminary injunction in the US is relevant under 39A, then this application should be against all the defendants who are obliged to pay $533 million. Instead, it's a targeted attack to harass a non-resident with no assets to get a travel ban on him, knowing his father is here with cancer. They know he visits here. There's no reason, using the same argument, that they could not make this application against camshaft and could not make the application against Think and Learn, and ask your honor to say, give this proprietary injunction against all of them because you have jurisdiction. No, no. 39A, I agree with you, is quite relevant because it demonstrates there's only two bases. And it also demonstrates when you review paragraph 9 of your order, there is literally no utility to this order. And they haven't demonstrated the utility. So then I go to, is there a serious issue? No, there's no serious issue. There's no final order according to 39.1, forgive me. And then 39.2, that clearly is a future event, which they presented no merits. So if we turn then to paragraph 41, their own words, the critical question is whether the counts on the basis of the U.S. preliminary injunction was granted have been decided. I concede count 1 against Byju Ravindran is not decided. No problem. That's a fact. I don't have to concede anything. It's a fact. So it's a critical question that is now answered. So what's the consequence? The consequence would be that you theoretically could continue a proprietary injunction. That's the argument they make. However, there is no utility to that order. There is no benefit because there's no evidence that he can do any of those things. And so the argument from claimant will be, well, if you can't do any of those things, then it doesn't matter if we give an undertaking or security for costs. That was their argument. If you can't get damage anyway, so what? You can't be damaged. So what? So leave the order in place. No, that's the cart before the horse. The order to be in place has to have utility. Then we can go to whether or not there should be undertaking. There is no utility. And as a consequence, for that reason alone, it shouldn't remain. The argument later in the freezing order, starting in paragraph 48, interim injunctions cannot be enforced in the DIFC. It relies on the position in England. 53, the fourth is most critical reason, it's not final, conclusive, and enforceable. That goes back to 39.1, excuse me, 39.1. So 53 goes to 39.1. We've already shown it's not final.
I'm sorry, can I just stop you for a moment, Mr. McNutt?
Please.
You've chosen to go through the matter by using the claimant's submissions, and the section you've taken me through, section, I think it starts at section C, starting on page 8, is the proprietary injunction. And then in particular, on section C3, serious issue to be tried, what the claimant does there, what Mr. Montague Smith does, is put forward what the claimants understand to be the arguments which you raise, and then he responds to them. And the way you're going through them, do I understand that what you're saying is, yes, those are the arguments that you raise, and you're telling me why Mr. Montague Smith's answer to them is wrong?
You're correct.
Yeah.
Yeah, and I'm doing that because he raised all of these points in his prior submission, points 1 to 6, and then plus 2 more. So I'm just trying to dispose of them.
But I just wanted to understand that the points that you make are those which are summarised by Mr. Montague-Smith in his section C3.
Well, the points that I'm making are that he says the critical question is to decide if the basis of the injunction was granted or decided.
Okay.
41. And that paragraph 41 ultimately ties to paragraph 61 of his skeleton.
Okay.
Okay. And what I'm saying is if we go down his road, that the counts are not decided and count 1 against Byju is not decided. And as a consequence of it not being decided, his argument is the proprietary injunction should remain. My rebuttal to that is no, it should not remain because it has no utility to remain, because the injunction, when it was granted for a preliminary injunction related to monetary claims. What Peter Van Tol says is because the monetary claim is decided, the fraudulent transfer, that claim is decided, the other claim not decided, whether it's Byju claim, count 1 or other claims, there can't be double recovery. So because count 1 is decided against Camshaft, they can't ask Camshaft to pay back $533 million and then later say that Byju has to pay under count 1 another $533 million. And as a consequence, count 1 is formally not disposed of. That's true against Byju. But from a preliminary injunction to preserve the disposal of assets inappropriately to prevent that, that is satisfied with the partial summary judgment because the $533 million has been ordered under count 1. And as a result, the Byju, there's still a claim against Byju is pending. That's why, Your Honor, I was happy to concede it because frankly, it doesn't cost me monetarily anything. It doesn't cost Byju anything. Camshaft is already having to order, they already have to pay it. Byju under count 7 already has to pay it. But if Camshaft pays it, Byju doesn't pay it under count 7, and Think and Learn doesn't pay it under count 4. It's not $533 million times 5. They're jointly and several for all counts together. And that's why my point to you is that he's saying there's a serious issue. There's no serious issue. They themselves have the power to enforce against themselves in India with Think and Learn. Count 2. They can collect this 533 from Think and Learn. They can collect this from Camshaft. They are saying they need a proprietary injunction only against Byju, only against him. Why? Well, they want to be sure for some reason that the preliminary injunction in the US that they say still exists is brought forward into the DIFC. And somehow they're trying to argue it's not duplicitous. It is duplicitous. It's clear it's duplicitous. And they don't bring the other defendants. And there is no utility. And so when I look at his arguments, 41 dealt with. Second, starting on paragraph 48, interim injunctions cannot be enforced in the DIFC pursuant to 34.4. Let's assume you apply the common law and it can be enforced. I'll go down that road. It can be enforced. Okay, let's move past that one. It can. That doesn't mean that it should remain enforced. It just means it could be issued. And the question again goes back to Your Honor. If you want to issue it, if you're inclined to issue it, and you're inclined to believe that you have jurisdiction to issue it, fine. Should you issue it? Is there a serious issue warranting you issuing it? A, it's duplicitous to the U.S. preliminary injunction. They say it's still in force. B, it has no utility being issued in this jurisdiction. Because in this jurisdiction, there are no assets. Their own investigation confirmed by their witness statement of El Gatit, and his evidence proves that after the order was given, in order to police compliance with his asset disclosure, they conducted an expansive investigation locally, no assets in all of the UAE. So we have a defendant with no assets in the UAE, no evidence of any 533 million, no evidence that he can do anything with the 533 million controlled by OCI, admitted by claimants controlled by OCI, yet they would like you to give a proprietary injunction. And I'm saying, okay, how can they argue they want a proprietary injunction and claim there's a serious issue? I don't think they can win that test. There's a serious issue. And if I go to the balance of convenience, my good learned friend mentions, he first argues, well, that's an undertaking issue that we say. We say it's an undertaking issue, not a balance of convenience. No, let's start with balance of convenience. How is it convenient if the preliminary injunction exists in the states, as they claim, and there is no ability for Mr. Ravindran to do any of the items listed in paragraph 9, because claimants admit he controls none of it? How is it possible that it is not duplicitous? And how is it possible that the balance of convenience falls in favor of claimant when claimant has failed to present any merits arguments for a good and arguable case for count 1, when they failed to present any evidence whatsoever as to why a bankrupt company, plaintiff is bankrupt, we'll get to it later, not today if you don't want, we can do it tomorrow, why their undertaking is deficient. A bankrupt company has an undertaking they represent, don't worry, we'll pay for the damage, but in the evidence you have, and I'll give you the citation, we don't have to look at it, but I'll give you the citation, you can look at it at your convenience. They have failed to comply with a UK court order for costs. They provided an undertaking in the UK, same undertaking, standard form undertaking, and they didn't pay it. So they're in violation of the UK court order, having not paid it. And one moment, I'll give you that citation, please. And you guys can be really quick to the UK OCI order. Here, it's bundle 3067. It is exhibit 50 to March 1.
Sorry, 3067.
Yes, please.
That's in the United States Bankruptcy Court, an order.
Oh, forgive me, I've got the wrong citation. 1 second, please. I might have transcribed something. 1 second. What? That's the OCI order. Yeah. My colleague, so it's 3535. Let's try that. Yeah, that's it. I'm sorry. 3535. Now, the significance of this order is it's against OCI, the party with the money. Plaintiff went to London to get orders, were denied. They've initiated a claim against OCI in Delaware. Where did the money go? Claim OCI. They are ordered to pay a nominal amount. It's nominal. They haven't paid it.
Sorry, you're going to take the judge to the evidence of that. Where's the evidence of that?
The evidence of them not paying it I will find that for you and give it to you in the morning. They have not paid. Are you, no problem. Are you, why don't you confer with your client tonight and ask them if they paid it? We'll clarify it for the judge. I guarantee they haven't paid it. I know they haven't paid it. I'll find the evidence to show they haven't paid it.
Right.
That's fine. That's fine. And you're correct, counsel. I understand the question. That's a fair question. I'll find it. But assume for one moment that there's an order, and therefore, Your Honor should ask the question yourself, was it paid based on our submission? And my good learned friend can answer that directly for you. On information and belief, I am aware it is not paid, or at least it wasn't paid as of, I'd say 10 days ago. I haven't spoken to anybody about it since then. And I didn't know I was coming on board for this today, so I didn't ask somebody ahead of the hearing. But that's why I said, please let me try to find it. But they haven't, there's a court order in the UK with a nominal amount, and if I'm correct that they haven't paid it, and at the same time, they are saying, well, the balance of convenience, we should be allowed to maintain this. It would be appropriate for security for cost or fortification to be provided to ensure policing of this. But I submit, let's avoid the whole security for cost and fortification issue, because the proprietary injunction shouldn't remain for the simple fact, how can Your Honor police compliance with it? How is there any utility without a shred of evidence that the defendant has the capacity to do any of those things?
I think you've made that submission several times now, Mr. McNutt.
Yeah, this was only in relation to, I'm sorry, to the balance of convenience. So I made that in serious issue. I made it for convenience. And then they say justice and convenience. The only argument is that the preliminary ceased to exist. Assume it doesn't. And then I said, we'll deal with full and frank disclosure. Assume even there was no violation of full and frank disclosure. That doesn't change the fact that I've already submitted he cannot do this anyway. And I'm trying to shorten the day on the full and frank issue. So if we say then there's no issue on this, you'd only have to consider full and frank disclosure on points relevant to omissions or misrepresentations as to the utility of the proprietary injunction, which would mean they would have had, as I indicated earlier, to represent to you somewhere in the ex parte hearing that there was some utility to granting this and that it was not duplicitous. And they failed to do that. They failed to present any evidence as to the benefit of this order for them as a party in these proceedings. And I'll leave it at that for today. Thank you.
Well, sorry, I wanted you to complete your submissions on the set aside.
What I meant by today is on the submissions, should you give my good learned friend a right of reply? You've already agreed to give me a right of reply, but you may want to go home before we finish that, and that's why I said that.
I wanted to go home some time ago, but
fair enough.
I am determined that we'll get through this, and hence I want to see you finish your submissions on the set aside application. Now,
I have finished the submission.
Yes, if Mr. Montague Smith, when Mr. Montague Smith makes some response, you may reply, not repeat the submissions you've made, and not raise matters which Mr. Montague Smith didn't argue, but you may reply. Now, before we get to that, have you otherwise completed your submissions on set aside?
I complete my submissions, and I would ask for the same test to be applied to my good learned friend so that he does not repeat, which will rapidly finish this discussion today.
All right. I didn't understand. Have you completed your submissions on the set aside?
Yes.
Yes. All right. Mr. Montague Smith, how long do you think you will be?
Well, it's difficult to know. I mean, we count about 15 allegations of full and frank disclosure that have been bandied about along the way. I do need to show you a couple of them because they're just not true. So some of the things that the lawyers are telling you about things that took place in this court are false. And that just needs to be brought to your attention. It sounds like they're abandoned, but it is difficult to know quite what's left of the full and frank disclosure, and it's very unacceptable. But there we are.
Perhaps I can ask Mr. McNutt, can you identify by reference to your submissions or otherwise, what are the full and frank failure to fully and frankly disclose that you maintain?
Thank you, Your Honor. Concerning the full and frank related to the set aside, the debate surrounding the finality of the partial summary judgment, which is first basis under 39.
What I'm looking for is not a general description, but a specific, and where they are enumerated, I assume either in your submissions or somewhere that you can point to identify the precise allegation of failure to fully and frankly disclose. And I want it identified in precise terms, not just a general description.
Yeah, I appreciate that, and I intend to be precise, very precise. I'm simply saying that the evidence of the omission, and I can't prove something that was, how did I say? The disclosure made at the ex parte hearing concerning the set aside did not include the likely defense that the partial summary judgment is not final and enforceable and these other issues. And as a consequence of that failure...
Have you stated that somewhere in your submissions or elsewhere? Can you point to me somewhere in the papers what each of these allegations are? Because they're serious allegations, and the claimant should only have to answer those which have already been identified, not ones which are identified on the run, as it were.
You want to perhaps, I hesitate to cut across. And what I was preparing to do was do much like the last time, pick up the allegations that are made on paper and deal with them briefly, and then pick up the ones that are new in the skeleton and deal with those briefly, to the extent that I can, because obviously my threshold argument in relation to those is they're not on the table, because then we haven't had notice of them. And I just worry that if we continue to ask Mr. McNutt to clarify his case, we're just going to end up extending this indefinitely, and there's a little bit to get through. So if you're confident that I can do it that way,
I can answer his question. Thank you. No, thank you, but I know in our skeleton argument, there are very precise allegations. If you start, please, at paragraph 75.
So I was proposing to take Your Honour through these, but...
If you just identify them for the moment, Mr. McNutt, I don't want you to address them. They're at 75 and following. Is it 75 through to where?
That 75 is that the plaintiff was never itself anything other than a special purpose vehicle.
Okay.
That 76.
If they're in writing, if you can just identify to me the paragraphs.
I am. 75. 76. 77. 78, 79, 80, that's it.
Well, not quite. It carries on, in fact.
What about
Oh,
82?
1 second.
Then?
No, you're right. Well, 1 second.
82, 85, 86, 88, 90, 91, 92.
No, excuse me. Thanks. I know how to present my own skeleton. Thank you. I'm allowed to take a pause. Your Honor told me before I could take my time to make sure.
I'm sorry, I thought you said that's it.
No, that's it for that section. You go to the next section.
Oh,
I'm going to go by the headings because I was trying to simplify the paragraphs. The next heading has 3 paragraphs. So I'm just trying to simplify things. That's why I needed a second. The preliminary injunction ceases to exist. I'm not going to argue that. Okay.
Paragraphs 82 to 84, you're not arguing that.
Correct.
Okay. All right.
The 85 to 87, I am.
Right.
88 to 89, I am.
Yep.
90 to 91, I am. And that's it.
Okay.
Thank you.
All right. Thank you. Now, it is late in the day for me, at least, Mr. Montague-Smith, and starting to get late for the court staff. What I propose to do is this, that tonight, Mr. McNutt has told us that the defendants in CFI 050 are going to, I'm sorry, we're getting some feedback, I think. The defendants in CFI 050 are going to put on some sort of skeleton for submissions about the collateral use arguments. I propose, unless it's going to inconvenience you, Mr. Montague-Smith, to deal with that first thing in the morning to ensure that that application is completed. If we will then continue, I will continue until 4 p.m. Dubai time tomorrow, perhaps some slight extension if that is likely to be effective, but otherwise the matter is going to have to be adjourned. If you can't complete the matter in that time, then regrettably, and as undesirable as it is, the matter will have to be adjourned, part heard. But we'll hear the collateral use argument first thing in the morning so that that matter can be completed. Do you want to make any comment on that, Mr. McNutt? No. All right.
I think it's a great suggestion. That's a great suggestion.
All right. All right. Well, thank you both. I thank the court staff for sitting on later. We will resume at 10 a.m. in the morning.